Hello, reporter room investigators. My name is Jessica Davies. I'm an investigative journalist. Today, we're going to be attending the Bryan Kohberger hearing. Oh, we have a little bit of a pre-show planned for you guys. There's so much stuff to go through in this case. So let me just welcome Spirit Walker. Welcome on becoming a new YouTube member. So glad you are here. So I'm an investigative journalist. My job is to investigate crimes, crime scenes, and potential suspects and share with you how to do the same thing. So if you haven't subscribed, please do like, share, and leave a comment. And everything I'm sharing is my opinion. This video is for educational and entertainment purposes only. So thank you to our subscribers, our mods, our channel members. Our channel members are the ones with the verified green, red, and blue check marks. So today we're going to be talking about Ann Taylor and the defense team. And we're gonna start with this, and then I'm gonna say hello to chat. So the defense team have been polling prospective jurors, and the prosecution is alleging that they're using misleading questions. And what I mean by that is the questions, at least according to the prosecution, are actually leading the potential jurors with misinformation or disinformation. So what the prosecution is saying is that the questions are not based in fact. Is Ann Taylor trying to force a change of venue? Is she just trying to advocate for her client? The problem with the defense team surveys is that questions were reportedly posed to potential jurors that included assertions. What the prosecution is saying, these assertions are simply not true. So Ann Taylor and her defense team were actively spreading misinformation. This is according to the prosecution. And for those of you who tell me that, for those of you that I just want to remind me always say Bryan is innocent until proven guilty. I do talk about this case in terms of Bryan because he's the only person who's been charged and who's sitting in jail. And obviously the hearing is, for him today. So we're going to talk about this case in terms of him. You can see I have Judge John Judge's page ready to go, and I have multiple packages to share with you. So let me take this down and share this instead. Okay. I need to add it. All right, it's just not fussing at me today. There we go. Okay, we got it now. All right, so we'll start this. My source on this is Oxygen News. So, and the hearing's going to start in just a few minutes. I have the page up. It's going to start a little past 4. So the defense in BK's. Can you guys see this? Okay. Let me just check. Yeah. Okay. Let me move myself. There. That's better. All right. So the defense in Bryan Kohberger's trial, they're barred by the judge from conducting these surveys of potential jurors. So Ann Taylor says that the defense team says that her team was simply collecting data while polling potential jurors in Latah County. They say they did not disclose any concealed information about the case. But the prosecution thinks that they were revealing. They're alleging that they were revealing information. So we're going to hear, there's going to be some fireworks today. And are we going to get a trial date? Is Ann Taylor going to let any more slip ups like what we had last time? So this is what Ann Taylor says. She says on March 22nd of 2024, late on Friday afternoon, the state filed this motion to prevent contact with potential jurors. The motions included attachments. The late Friday afternoon filing was a strategic action by the state. So, of course, she wants to position her client, because she's a good defense attorney, she wants to position him as the underdog, right? Because people instinctively root for the underdog. So she further explains that the defense was in the middle of conducting these surveys of potential jurors, a process that they had notified the prosecution about, and the defense argued that the order violated Kohberger's right to due process because the order came before a hearing that could be held about the issue. Well, here's the thing. The judge has said, he's already ruled that neither the prosecution or the defense should be contacting jurors. So, and I don't, so I think it's not up. It doesn't matter if the prosecution gave her permission or not. That's what we call a straw man argument. Instead of arguing whether the judge gave her permission or not, she wants to argue whether the prosecution did or not. And it doesn't matter what the prosecution decides. It's what the judge decides. That it's the court imposed gag order, not the prosecution imposed gag order, not the defense imposed gag order. It's the court imposed gag order. So it doesn't really matter. I think Ann Taylor's putting up the prosecution as a straw man, but prosecuting attorney Bill Thompson, he requested the judge's order in a motion that was filed under seal. So we can't see it. I don't know what it says. If I had it, I would tell you. I don't know what the information is. Hopefully we'll learn more at the hearing today. So on March 22nd, Judge John Judge wrote in an order made public on Monday that, quote, both parties are prohibited from contacting potential jurors about this case, including third parties, until further order of the court, and a hearing on this issue will be held as soon as practical. Well, we know Ann Taylor wants a change of venue. Is she trying to trigger one? So come on in, come on in. Let me say hello to chat. Please give this a thumbs up. Help me out with the YouTube algorithm and consider sharing this on your socials. Welcome to our newest channel member, Spirit Walker. I'm glad you're here. Hi, Jeanette. Jeanette says, hello from, tell me where you're from, you guys. I'm from Idaho Falls. Thank you for the hours of work you put into this case and for sharing information with all of us. It's my pleasure. For those of you that are in my Facebook group, you know that I have a sore throat and I have a chest cold. So I'm going to be sipping water. And once the hearing gets going, I won't have to talk too much. But we did want to do a little bit of a pre-show together. Hi, Njaz. Good to see you. Thank you to our mods. Hey, Louise. Hi, Julia. Glad you're here. Julia says, is the hearing in court with Judge John Judge? Yes, it is. It's going to be with Judge John Judge, and I have that pulled up. So as soon as it starts, we're going to go straight into that. And we are going to be, I'm going to air the hearing live. So we're going to do live. And when I air it, I don't talk. Just so you guys know, when I'm watching this, I hate it. It's just a pet peeve. I hate it when people talk when I'm trying to watch a hearing. I prefer to watch quietly. So just so you know, we're going to do this pre-show together. We're going to chit chat now, and then I'll be able to talk to you in chat. I'll be able to drop you comments, on my computer and talk to you in chat, but I won't be talking over the trial. I absolutely cannot abide that. I just like to hear what the judge has to say. So when is the hearing? It starts right around 4:30. And Jazz is saying 4:45. I have 4:30 on mine. So I don't know unless they've changed it since I got my notes together. Julia says her coworkers are here in Germany. Welcome, Germany is in the house. They don't always say why they were so behind on this case. They don't understand. I know it is a lot. It is a lot. And Ann Taylor was testifying before the Idaho Senate this week too. We're going to talk about that a little bit also. Let me say hello to chat. Come on in, you guys. Come on in. Hi, Leslie. Hi, Holly. Holly says, I could be wrong. This is my guess. Y'all remember the dust time they backed up the box truck to the front door? My first thought was they are taking them out. Wasn't the furniture. We all saw the furniture being brought out later. Let's see. Thank you. Great. Vid's music is here. And Jazz is here. Brother Mike is here. Please give me a thumbs up on your way in. Help me out. Jane is here. Florence is here. We're going to have a great chat. Tell me where you're from. Happy to see you guys. Grunge Truck thinks it's desperation. Rand says hello. So what is the hearing about? Well, we're going to hopefully get a trial date. Ann Taylor wants a change of venue. So let's talk about this hearing. Create Vid's Music says, I think the defense is totally getting ahead of themselves. Things will change in Latah County in a year or more as far as the jury pool. Yeah, I agree. I think that I mean the prosecution just wants to try to seat a jury. They want to try. And then if they can't, then they can't. Great to see you guys. Hey, Pam. All right. Well, come on in, guys. Tell me where you're from. Make yourselves cozy. Get yourself some water. We have a lot to dig into. Let me just go ahead and just start with this because I have multiple packages to share and we're going to go through the warrants also. And I want to try to get through all of this before the trial starts, but before the hearing starts, because once that starts, I'm going to go radio silent. We're just going to watch it. Okay. So the defense wants a change of venue. So, and the prosecution wants a trial date. So we're going to see how the judge, you know, factors all these wants and needs in. Is the gag order going to be lifted? Is it going to be modified? Is it going to be rescinded? It'd be great. I mean, I would love for the gag order to go away, but that is to protect Bryan Kohberger's right to a fair trial. So I do want him to have a fair trial, of course. So the jurors surveyed in just the juror surveys in dispute are likely part of an effort to prepare for a change of venue hearing. So Ann Taylor is saying that she just is surveying the jury because she wants to potential jurors because she just wants to see if she needs to move. And she actually decided, I'm going to tell you that in just a second, so please stay with me, but she decided if she needs to move the venue or not. So former prosecutor and defense attorney David Gelman told Fox News Digital that BK's attorneys filed a motion for a change of venue earlier this year, arguing that the small community of Latah County will hold bias against BK's, I'm watching my words, it's not what it says here, but infringing on his right to a fair, impartial trial. So this is what this attorney, he's a defense attorney, he's also a former prosecutor, he says, in order to gather sufficient evidence to support their application, the defense retained an expert. Now, this expert who sampled the potential juror pool to assess potential bias in Latah County. This is what he told. And my sourcing on this is Oxygen True Crime. So this was done by way of telephone in a survey to 400 residents. Now, the prosecution, they were not having it. They took issue with it. And they say that the questions include information that was not made public. And they're accusing the defense of violating a sealed court order relating to the survey. They are claiming that the defense team discussed specifics of the case with the public and disclosed information that would be inadmissible during trial. Wow. I would love to see those questions. So Ann Taylor, she was not having it. She rebutted what the prosecution says. She said, quote, the defense is asking prospective jurors in the county of Latah as to what information they're aware of that was previously disclosed vis-a-vis press. So very, very interesting. So Gelman told the outlet there's a couple of things that do favor the defense. First, he said the surveys do indeed appear to be about gathering information as opposed to disseminating information. Second, even if the motion to change venue were denied, any potential adverse impact upon the jury pool because of the survey would not only be negligible due to the small number of jurors contacted, but also addressable during voir dire. So voir dire is once they pick out, their 50 jurors, then they can ask them questions and they can choose who they want to keep and who they somewhat, not completely, but the defense and prosecution can decide what jurors they want, what jurors they don't want. So they can address it during voir dire, which is kind of where we are right now in the Chad Daybell case, right? We're just about there. So the defense inquiry is a change of venue is motivated by the fact that Latah County is where the 4 students were done away with, and BK is charged with all 4 of their doing away with, I'm watching my words, and 1 count of burglary, because obviously he would have broken into the home to do this. Now, he is innocent until proven guilty. So prosecutor Bill Thompson said that this case has already, now his position is this case already has global attention. And I think that's evidenced by the fact that we have people here from Germany today. So He said that a change in venue is just going to be redundant. He wants to try to seat a jury in Layton, and if they can't, then move the trial. So, but the trial hasn't even been set yet. So are we, maybe jumping the gun a little bit? What do you guys think? Let me grab the next one. And then I'm going to check in with chat, and we're going to go through those warrants today. But I want to go through this one. Okay. We're going to talk about what's going to be argued today is what we're going to start with. And I am watching the John Judge. I do have it pulled up. Okay. So let me go ahead and see if you guys have any questions, any comments. Hey, Easy Mac. Brother Mike says, set the date. Yeah, I think we all would like to have the trial date set. We can all argue about jurors and surveys and all of that stuff. But, I think we would like to have a trial and change a venue. I think we just all would like to know, like, when is this going to get started? Is it going to be summer of 2025? Is it going to be sooner? Grunchick said, desperate, looking for something that the jury might buy. Julia says, let them get to the trial in 2024. Penny says, she should have disclosed what she was doing beforehand instead of being sneaky. And I think this, she's saying that she told the prosecution. I don't think she did, or at least she didn't say it in a way that, from what I've heard, somebody that got a call with the information is who tipped off the prosecution to it. Now, Ann wants to say that, Ann Taylor wants to argue, she wants to argue the straw man argument. The prosecution gave her permission, but the prosecution and defense don't get to decide when they want to waive the gag order or not waive the gag order. That's up to Judge John Judge. He is the neutral party in this. So the prosecution feels like she's being sneaky. Ann Taylor just feels like she's doing her job. Let me know what you think about this in the comment section below. Mike, hey, good to see you. Susan says the survey was done by an outside party. Yes, it was done by a third party that was hired by the defense team. Holly says, y'all come on. Remember, she's been complaining about not enough time. Yes, and she finds time to pound the pavement, pulling potential jurors. Well, her argument for that is going to be, well, I need to do this because I need to know if we're going to change the venue. But I agree. Don't we want to set the date? And can't the venue be decided once a date is set? I think it could. Steve says, justice for these kids. Yes, thank you for remembering who the victims are in this. Michelle says, hello from New Jersey. Jane says, I don't see how she can pull potential jurors. Well, she did. She did it. It's done and dusted. Say No says, the underdog here are the victims. Yes, I agree with that. I mean, I think they're getting lost in all of this, which is really, really sad. People are kind of losing track of Ethan's, not everybody, but some people seem to be lost track of Ethan, Xana, Kaylee, and Maddie. And this happens so much in these trials where we're just, talking so much about the perpetrators or alleged perpetrators or potential perpetrators that we don't spend enough time focusing on the victim. Susan said they paid the survey company to do it, so the judge had to have seen this. No, he didn't. That's why he put the kibosh on it on the 22nd. Let me share that. I'll share the next bit and I'll show you the receipts. Mike says, I don't know what. Instead of Ann Taylor, Spam Taylor. Okay. I thought you were talking to somebody in chat, and I was like, I don't think I have the right comment. Create Vids Music says they haven't even had the hearing for the change of venue yet, so why do the survey now? Because she's saying, Ann Taylor's point is that she says, I have to have the survey to know if we need a change of venue or not. So she wants to talk about change of venue because that's what she wants. She wants delay, change of venue, change of venue, change of venue. Prosecution wants the trial to be held in Latah County where the crimes were committed, and they want to set the trial date as soon as both parties can get ready. So they've offered March of 2025 as a compromise because they wanted to do summer of 2024. Ann Taylor said she couldn't possibly be ready. So as a compromise, they came back as March of 2025, and Ann Taylor still said no. So, right. Julia says, we don't need the hearing. We need a trial. Well, we're getting the hearing today. I wish I had a trial for you, but I don't. Jane says, exactly, judge gives permission, not the prosecutor. Yeah, her saying that she had permission from the prosecutors, that's a straw man argument, because the prosecutor doesn't get to decide if they can waive the gag order or not. That is for the judge to decide. So, but her job is to do everything she can do to protect Bryan Kohberger, and she's doing it very well. Claire says she wanted a speedy trial, then waived it when the evidence became harder for her to prove innocence. Yeah, and we have a trial. Scott Reich, who runs Crime Talk here on YouTube, said he felt like Ann Taylor and he felt like Bryan Kohberger's best chance to beat this would have been to do a speedy trial, because the prosecution is not ready. There is so much digital evidence. I know people are saying, well, Ann Taylor doesn't have everything. And I'm like, yeah, the prosecution's still going through. She has 95% of it. This is what both sides agree on. But they're still going through stuff too. They had a little bit of a head start on the defense team, but if the defense team needs until summer of 2025, I think, yelling, I don't have everything yet, if we're not going to go forward till 2025, we could just put that to bed. That's, again, just posturing, trying to grab headlines, in my opinion. Easy Max says, Ann Taylor has 81 terabytes of evidence to go through. So why is she pulling for potential jurors? Well, she wants to focus on, she doesn't want to set the date. She wants this hearing to be about the change of venue. Prosecution wants this hearing to be about setting the date and please give me a thumbs up. Help me out with the YouTube algorithm. So yeah, you guys have great comments. I love reading your comments. Susan says, the survey company got the questions from 3 local newspapers. Thanks for that. Do you have a source on that by any chance? So I would love to pull it up. Brother Mike's saying we have a great Facebook group. We do. Donna says she's from Knoxville. Hi, Esmeralda. Good to see you guys. I'm so glad you guys are here. Hey, George. All right. So I won't say I'm feeling better. But I'm feeling a little better, but I'm not going to say I'm all better. I was going to do a second live after this on the Sebastian Rogers case. I did move that to the weekend just because I felt like my chest was not going to do a good pre-show for you guys. Get through the hearing and then still be able to do a good live. So I just went ahead and moved that. But I have, I think, 3 more videos coming out this week. I have another one I'm uploading when we're done here. So we have lots of stuff going on with the channel, and we're going to start the Chad Daybell. And for those of you that don't know, Chad Daybell is a capital punishment case, just like this case is. It's also in Idaho. So, and it's televised. So right now they're doing jury selection, which is about as exciting as watching paint dry. So as soon as the trial starts, we're going to do that live here on this channel. And so anyway, come on in. All right. So let's get into the next article, because I have multiple packages, and I'm just going to check in with John Judge. I just want to show you he is not live. We are not missing anything by my going through the packages. Okay. So can you guys see that? Nope. I have to re-grab it. Let me get that for you. Okay, so I do have that pulled up. We're ready to go when he goes. Okay, so BK's defense team reaching out to potential jurors with the survey before the judge banned the contact. So my source on this is Fox News, and I pulled them up because they are referenced by the other article. So Bryan Kohberger's lawyers alleged public bias. So now Ann Taylor's saying we got the survey done, and now she's taking the next step, which is the public is biased in Latah County. But this is, residents called the police after being contacted in that juror survey. So I don't know what was going on. I can't wait to hear this hearing today. People don't like spam calls. It could be that. So this is what the start of the article. People don't like spam calls. BK's lead lawyer has accused the public of bias against her client, who is suspected of doing away with Ethan, Santa, Kaylee, and Maddie, after the Latah County residents called the police to report a defense expert contacting them for a survey. So I know some people are like, oh, they overreacted. If you're not sure, say something. If you're not sure if this is appropriate or not appropriate, they say if you see something, say something. If you're not sure on, say something. So I don't, if you're not sure, and I think it's a good thing to say something. What if it was the prosecution doing this? you know, Again, say something. So Ann Taylor, she is not having it, but she says after the afternoon filing on March 22nd, 2024 was done with the intention of obtaining immediate order without a hearing. Well, of course she wants a hearing, because what does a hearing do? Delay, delay, delay. It said the judge just shut it down and said, no, there's a gag order. The prosecution and the defense, nobody's talking. So she wrote, of note, due to the bias and interconnectivity of Latah County, citizens called police and prosecutors about the survey. Well, I don't think that just calling the prosecution about a survey, because I think if the prosecution had done it, they still might have had somebody call about the survey. I think the problem is she didn't get clearance from the judge to do this survey. So I don't, but she's not going to, you know, admit that part. So the judge banned the contact, though. So he gets to say what he wants, how he wants to run this courtroom. And remember, this gag order was put in place to protect who? To protect Bryan. It's to protect him and his right to a fair trial. So the survey is part of the defense team's attempt to gather evidence ahead of a change of venue in hearing, in which Kohberger's team will try to have the case moved to a larger jurisdiction with more people in the jury pool. And Taylor, in recent court filings, she is accusing Latah County Prosecutor Attorney Bill Thompson of trying to skirt due process in his request to have the court ban both sides from contacting potential jurors. So that was a mouthful. Okay, so I don't know. I'm sorry, I'm laughing because I couldn't get that little phrase out. So I don't think this is really fair on her part. I think she's trying to dirty up the prosecution. Again, her job is to position Bryan Kohberger as the underdog in all of this. And maybe people will forget that there are 4 innocent victims who were in their own homes, in their own beds, minding their own business, not bothering anybody, and that someone broke in and did away with them. And I don't think this is right, the way she's going after him, but she's going to do what she wants to do. All she needs is one juror. So, she said the ability of a prosecutor to have an order signed by the judge within the same building within a few hours of filing. So she's mad at how fast the prosecutor got the call and went right to the judge with it. But again, she wants to argue with the prosecutor. It's not his call. This is Judge John Judge's call, not Bill Thompson. He just went and told the judge because he got a call from the police department. What is he supposed to do? Sit on his hands? No, he has to tell the judge. She should have cleared it with the judge. That's my opinion. Let me know what you think about this in the comment section below. Should Ann Taylor have cleared this with the judge prior to contacting potential jurors? So she is not having it. She is saying that the ability of the prosecutor to have an order signed by the same judge within the same building, I don't know what that matters, because the jail is also part of the same building. BK's in the same building. And the specific fear of the defense had articulated to the state during the March 21st, 2024 meeting is the evidence of the state's intention to facilitate a due process violation. Well, again, I don't know, because I have questions about that. If anybody's violating due process, I think it's her, because she didn't clear it with the judge. She should have asked him. So Ann Taylor's office hired a social psychologist named Brian Edelman. Now, he was conducting the polling. In her filing, Taylor conceded many, not few, not some. She conceded many of Edelman's questions about media influence are not factually correct. So this is where I think, the prosecution and maybe the judge, are taking issue with it. If you're telling the jury stuff that's not factually correct, that's not true, and potentially influencing the jury pool, well then you're not going to get an unbiased poll. How is your polling data to be trusted if you're not telling them the truth? If your information that you're giving them in the poll is not factually correct? Well, we'll see what the judge decides because it's not up to me. So Edelman, in the signed declaration, denied violating any gag order with his questions. None of them included any information that was not widely reported and available in the public domain. I don't know. I don't know. What do you guys think? So Thompson, he looks like Santa Claus. That's the prosecutor, the head of the prosecution team. He accused the defense of violating a sealed court order regarding the survey by discussing case specifics and disclosing information that would be inadmissible at trial. So just because it's in the public domain doesn't mean the prosecution and defense get to discuss it with potential jurors. He also alleges that the questions on the juror survey violated the judge's restrictive gag order and asked the judge to cut off contact. Judge John Judge agreed, banning juror contact until further notice and scheduling a hearing as soon as practical to discuss the motion. So we're going to be talking about that today. So there's going to be some fireworks today. We're going to check back in. Let me check in with chat, and we're going to, if we have time, we're going to go through the warrants also a little bit. But I am watching. I am checking this. I just want you guys to see that I am right here ready to go. When he starts, I'm right here ready to go. And I'm going to get real quiet and we're just going to talk about the case. All right. Christine says it's raining and 9 o'clock. Looking forward to this. I'm glad you're here, Christine. Micro Kimmy says, sorry if I'm sipping, but I have a chest cough and a sore throat. Kimmy says, I bet the judge will set a trial date today. Oh, I hope so, Kimmy. I hope so. Christine is all the way from the UK. Anne says, are you speaking trial today? No, we don't have the trial today. We have a hearing today, but we're hoping to have a trial date set today. Mike says, I hope so. It will help the Goncalves family. Pam also is hoping so. Okay. Looking for questions, guys. Did the defense know about the survey that they were doing? Well, yeah. Ann Taylor knew about the survey. She says she not only knew about it, but she informed the prosecution. But again, that's a straw man argument. The prosecution doesn't get to decide to violate the gag order. That's up to the judge. So that's what she wants to argue, though. Of course, she doesn't want to argue that she didn't get permission from the judge to do it. So we'll see what he says today. Kimmy says she's speaking it into existence. Yeah, we're all hoping we get a trial date. I can't type. My swiping doesn't work. I'm so sorry to hear that. Hey, Opinion Einstein, good to see you. Louise is here. We got Mary says, Anne needs to be reading all of the terabytes so we can get this case started. Hey, Wicked. Yeah, I agree. All right, I'm scrolling down because I'm looking for questions. There are so many motions filed for this particular hearing. Yeah, this hearing is going to be good. This is going to be a very interesting hearing. I'm looking forward to it. Grunstruck says, I don't understand why Bryan didn't jog from maybe a quarter of a mile, especially since he was a runner. I don't know. Because if he would have left his car further away from the house and left his cell phone further away from the house, but he also had time constraints too, and that he was trying to do this in the cover of darkness. So maybe he just felt, and I've always told you that I thought he dextered out the car and that he stripped everything off. If his plan, and he had a monkey suit on, in my opinion, he's innocent until proven guilty. But if he stripped everything off, including the monkey suit, and Bethany said she saw somebody without anything on at this exiting the patio doors, and so if he stripped everything off, he may not have felt like he could run to his car. So his plan may have been to take everything off, drop it into a trash bag and get into the car to help reduce Locard's principle, which states that every exchange leaves a trace. This is why I think he left the patio door open. Judy says, I don't know why Bryan would sit in jail for 2 to 3 years or more while Ann Taylor piddles around with those terabytes. He's probably following what she is telling him to do, but I agree with you. I like think that maybe, you know, Scott Reich is correct. Maybe the better way to do it would have been to go ahead and force the prosecution to go right away. Do that speedy trial because the prosecution wasn't ready. They're still going, there's so much digital evidence. They're still going through stuff. So if the defense team had rolled the dice and just gone early with this, that might have been their best chance to beat this. At least that's what he says. And he is a defense attorney. Julie says, to see what the 3D model of the King Road house will look like, but seeing the crime scene where the pictures are published will be very hard for all. Only then can you imagine what the victims went through. Yeah, we don't know. We don't know. Welcome. Mike says, he's crazy. I think what doesn't make sense to us, I think makes sense to him. And Pam says, has anyone ever heard of pulling a potential jury pool? I haven't. This is newer to me also. But it just shows you the good defense that he's getting. He's getting a very expensive defense. The fact that they're able to hire outside people to come in and do this is, really helpful. Create Vids says Ann Taylor doesn't even want to set a trial date, but wants to start the jury process. Makes no sense. Right. It's delay, and move the venue. That's what she wants. She wants it away from Latah County, and she wants to move the venue. Mike says, and then there would have to be an investigation on who they called. Yeah, we don't know. Grunstruck says he would have had thermal running gear already, and it shouldn't have been because of the cold. Great point. All right. Rita says, I live 15 minutes from, not a comment related to this. Sorry. Pam says, I feel that the defense would be setting precedent that may change how trials proceed. It could be. Could be. And Mike says, yeah, he could go jogging with a knife in that monkey suit. He couldn't have the trash bag and be naked running down the street is probably what he was thinking. Let me scroll down. I'm just looking for comments. And Jazz says, for the victims' families, they need to set a date and soon. Natalia says, did they get the discovery yet? Well, Ann Taylor said she had 95% of the discovery, and she says that she is going to need until the summer of 2025 at least to go through everything. So before everybody says, we can't set a trial date until she has all the discovery, she can have the discovery up until a few weeks before the trial. Now, if we're like 3 weeks out from the trial and she doesn't have everything, then she could yell. But remember, the prosecution has to go through all of those terabytes of digital information also. They have to go through, they have a little bit of a head start, but not a huge head start. She came on the case. He was arrested on December 30th. He didn't fight extradition. He was brought back to Idaho, and she was assigned to him pretty quickly within just a couple of weeks. So prosecution has only had a 2 or 3 week head start. So if she needs until the summer of 2025 to go through everything, then let's just be fair and say the prosecution also needs time to go through everything. So this isn't directed at you, Natalia. I just think it's a great comment. I just wanted to address it because I do see it in my comment section. And remember, BK has not provided, and she's still supposed to provide an alibi. We haven't, first she said he was driving around. That was his alibi. Now she's saying there's going to be another one. I told you who I thought that was going to be. And Jess says, for the victim's family, they need to set a date and soon. I agree. I think somehow the victim's families do need to be factored into this. Just a balance, some kind of a balance. You guys are bringing great questions, though. Pam says, victims' families have rights, not just the defendant. When are the gameplays being allowed by the judge? I don't get it. Well, I think, we'll see what he says. Let's see what he says. Donna says, prosecution seems very confident that he is the guy. Creative Views the music says it's up to the judge. It is. It's going to be up to him. And he's the one that had the gag order in place. This wasn't the prosecution. That's why her saying, the prosecution knew. I don't think they knew, because as soon as they heard about it, they went straight to the judge. So I don't think they knew. I don't know what to say about that. I don't think they knew. I think if they knew, they wouldn't have gone running to the judge. But she wants to argue that the prosecution knew, therefore she had permission. But the prosecution and the defense don't get to give each other permission to waive the gag order for protecting the defendant, Bryan Kohberger. That is up to Judge John Judge. Leslie says eventually she has to allow a trial to go forward, and Taylor is dragging her feet. Yeah, and Scott Reich says she's doing the big bus defense, which is just delay. Because jurors move away, witnesses move away, witnesses pass away. She only witnesses' memories fade. She benefits by delaying. Mike says they have until September, I think. I think we should get a court date today. I'll be very surprised if we don't have a court date, you guys. I think we are going to get one. Natalie says there can't be court then this year unless it's after September, because they don't have the discovery. Well, the prosecution offered March of 2025. So that's, that was last month. So gave them a whole year to go through everything, and prosecution turning over the last 5% of what they haven't turned over yet, which they're still going through it. Even Ann Taylor said she wasn't throwing shade at the prosecution on that, but she sure did throw shade on them about the jury survey that she was conducting. Mike says trial should be set for March, July. I think they would set that in a time frame. I just think we need to set it. Grunstruck said he's used to cold weather in northern Pennsylvania. All right, so I'm just going to check in. I'm just going to refresh, make sure I am sitting on the live, just waiting for that video to pop up. Nope, I don't have it yet. Okay, so subscribe if you haven't already. And we should be getting started any second. I do want to thank our VIP, Jane J., our producers, George Brown and Jazz and Sasha Angel, and our channel members. You guys, if you would like to have your name appear like this and have a check mark next to your name, after 2 months it turns blue and stays blue. Hit the join button. It's next to the subscribe button. And if you haven't subscribed, subscribing is free. And it doesn't cost you anything, and it helps me out tremendously. So thank you to our channel members. You guys keep our channel running so nice and smoothly. And then we had some gifted memberships also that I want to just thank all of our super thanks, PayPal, and gratitude. This is for the last month and a half. This isn't last week. And I want to thank Njaz. She gifted 5 channel memberships, and I just want to say thank you for that. Okay, so with that out of the way, we're just waiting on the judge to get started. I'm going to move myself off this page as soon as he started. We're supposed to be starting in like 2 minutes. So I'm just going to talk, but I'm not going off this page, and I will hear the click when he starts. So the jury contact is typically forbidden, but surveys have been used in the past to bolster defense attorney argument for a change of venue. But usually you're not allowed to just do these surveys where you're contacting prospective jurors, especially in a small area like Latah County. So a hearing on the matter is scheduled for today. So we're going to find out what the judge thinks about this. And we're going to probably see some fireworks, because I have a feeling, Ann Taylor, she's gunning for the prosecution, and I have a feeling they're going to be gunning for her right back. I think this is going to be very, very strong. I did want to go through some of the warrants. So I don't know if I'm going to have time though, because we're like really getting close here. I just want to keep refreshing. He's not there yet. Okay, so as soon as he comes up, we're ready to go. So going back to the warrants, I just want to go through a couple of the things. So we know that what they found the .40 caliber handgun, a gun, a knife. I don't think it's the knife, but a knife, a pocket knife, empty gun magazines, and these were all found at his parents' Albrightsville, Pennsylvania home. So the gun could have belonged to his parents. I don't know if this pocket knife was his or it could have been his dad's. I don't know who the pocket knife belongs to. But per the warrants unsealed on Thursday, the police seized numerous items on the day. This is the day that BK was arrested, including his cell phone, multiple laptops, a knife, a pocket knife, the handgun, 3 empty magazines, black face masks, black gloves, 2 external hard drives. I think that's very interesting. If he left his computer tower behind at his apartment, did he back up everything onto the hard drives? Did he have any souvenirs on there? More articles of dark clothing and a green leafy substance in a plastic bag. I think we can guess probably what that probably is. Um, and then per the document, the police also found and seized medical and court documents along with various criminology books and criminology psychology books. Now, obviously, he would have had these because that's what his major was. So they also found a note to dad from Bryan, a note from Bryan to Montana, in addition to a notebook, a note, and a man's world drawing. Now, they went out to his car, and in the 2015 Hyundai Elantra, they found a shovel, gloves, coins, goggles, plastic Ziploc bags, floor mats, receipts, hiking boots, used water bottle, a wrench, a bandage, map, documents, among other things. I think that the shovel, depending on what kind it is very, very interesting. I'm just going to go ahead and refresh. And he is not live yet. Oh, here we go. We're up. All right. He doesn't have a sound up, but I'm going to boost it for you guys. Let me know.
All right, let's get on the record, please.
Let me move myself. There.
Okay, thank you. We are now on the record. This is State versus Bryan Kohberger, case number CR 29222805. Mr. Kohberger is here in the courtroom with his attorneys, Ms. Taylor, and maybe Mr. Loxton is not.
He's not
remote.
He's not remote, Judge, but I think Miss Massa.
Yes, I was going to go to her next. Ms. Massa is also participating remotely. State's represented by Mr. Thompson and Ms. Jennings, who are in the courtroom. And my understanding is Mr. Nye is remote. And Ms. Beatty?
She's not with us today. She's tied up with some other obligations, Boise Drop.
Okay, great. Thank you. Okay, so we have several issues to address today. And so maybe we should just start with the state's motion for order prohibiting contact with prospective jurors absent leave of court. Mr. Thompson?
Thank you, Your Honor. And to start, I want to help frame what the issue really is today. We are not here to debate whether the defense contracting for public surveys on public sentiment and that sort of thing is or isn't appropriate. That's not the issue at all.
I agree.
Our sole concern today is the nature of certain questions that have been propounded to residents of Lake Tahoe County by a survey company that's contracted by the defense. And we are specifically concerned with how those questions line up in light of this court's very clear non-dissemination order. I think the best place to start is to go to the court's June 23rd of 2023 non-dissemination order. And in paragraph enumerated number 1, starting at the bottom of page 1, the court ordered that counsel for all the parties and any of our agents and other attorneys are prohibited from making extrajudicial statements, written or oral, that the lawyer or agent knows or reasonably should know will have a substantial likelihood of materially prejudicing or otherwise influencing the outcome of the case. And that's essentially the language out of Idaho Professional Conduct Rule 346. But what is particularly important today is the next sentence. Your Honor directed, this order specifically prohibits any out-of-court statement which a reasonable person would expect to be disseminated by means of public communication that relates to the following. And among the items listed are the identity or nature of evidence expected to be presented at trial or any sentencing phase. Any information a lawyer knows or reasonably should know is likely to be inadmissible at trial, and that would, if disclosed, create a substantial risk of prejudicing impartial trial. And it goes further down to say this includes performance or results of examinations or tests. Our concern here is that the questions that are being propounded on behalf of the defense, and let me stop for just a moment. I want to be clear on this. We met with Ms. Taylor last week. Week before last, the 21st.
Thursday.
Yeah.
Before the Friday.
Thursday before the Friday when we filed our motion. Yeah.
Yes.
And we raised our concerns with Ms. Taylor. She confirmed for us that the survey was being conducted on behalf of the defense. And we raised with her the concerns we had about the specific language of the questions that were being asked. And Ms. Taylor represented to us, and I do not dispute this, that's why I want to make this part of the record, that she had not seen the actual questions themselves, that she had approved the topics that could be looked into during the survey. So I want to put that in the record that we are not accusing Ms. Taylor of drafting these questions verbatim and then say, go send these out to the public. We are concerned, though, that the people hired by the defense to conduct this survey did exactly that. And the examples of the things that are of concern can be found in the transcript of one of the calls. As Your Honor will recall, we had a person come to us who had received one of these calls, had actually recorded the call. And so our office prepared a transcript, and that was attached as Exhibit B, I believe, to our motion for order prohibiting contact. In addition to generic questions about the criminal justice system, here's where we get to things that concern the state immensely. Question: have you read, seen, or heard if Bryan Kohberger was arrested at his parents' home in Pennsylvania? Question: have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Question: have you read, seen, or heard that DNA found on the knife sheath was later matched to Bryan Kohberger? Question: have you read, seen, or heard if Bryan Kohberger owned the same type of car recorded on video driving in the neighborhood where the killings occurred? Have you seen, read, seen, or heard if the cell phone tower data showed that Bryan Kohberger made several trips near the victim's home in the month before the killing? Have you read, seen, or heard if the university students in Moscow and their parents lived in fear until Bryan Kohberger was arrested for the murders? Have you read, seen, or heard if Bryan Kohberger said that he was out driving alone on the night of the murders? Have you read, seen, or heard if Bryan Kohberger stalked one of the victims? Have you read, seen, or heard if Bryan Kohberger had followed one of the victims on social media? Your Honor, there is absolutely no question but that those questions are disseminating by means of communication evidence expected to be presented, evidence that could be or would be inadmissible at trial. And I will say there are a number of these representations placed in the form of a question, but representations of fact that are not true or that would not be offered at trial, or the performance results of examination tests. And these questions specifically refer to DNA testing. Now, I recognize that the defense says, well, all of this information is out there in the public media somewhere, but that misses the point. That's assuming that every person in Latah County who is called has followed all of this nonsense in social media, has followed extensive coverage. There are people who consciously avoid reading coverage or listening to coverage about this case because they don't want to. That's the fallacy of the position defense is taking here. So what the agents of the defense have done is they have gone out and interrogated 400 citizens of Latah County and embedded in them facts specific to this case, some of which are not even true, some of which would not be admissible in court. And those people, whether they had heard that information before or not, are now saturated with that information. That is exactly what the non-dissemination order was intended to prohibit. That is reckless conduct, and it's outrageous. They can ask a survey, and they can ask people, what do you know about the Bryan Kohberger case? What have you heard about the Bryan Kohberger case? What do you think about the Bryan Kohberger case? Do you have an opinion as to whether he's guilty or not guilty? Why do you think that? They can ask all those questions, legitimate survey questions if you wanted to do a legitimate survey of public sentiment. But these questions go far beyond that. And I recognize that that it is represented that the survey questioning here in Latah County with those 400 residents has been completed, but they're already saying they want to take these questions out to other possible veneers. Doing the same thing in other potential jury pools that they're doing with our own. That is far beyond acceptable. These are questions that, quite frankly, might not be able to ask in voir dire, much less into an uncontrolled, unsupervised environment without any bounds, and just recklessly feeding this information, which is sensitive. And it's particularly sensitive when it comes to information that the state does not believe is true, or the state does not believe would be admissible or would be offered at trial. On the issue of whether information already publicly available isn't included in Your Honor's order, which it clearly is because it doesn't say otherwise, we know that there is no exception in the court's order saying if the information is already publicly known, it's okay to disseminate it again. And indeed, that would be reckless for the very reasons that I just articulated, Judge. We would then be feeding information that is potentially prejudicial or that could affect the open-mindedness of prospective jurors to people who may not have heard it before. That's completely reckless. And so, Your Honor, based on that, we think this needs to come to a stop. We think if the defense wants to continue doing survey work, which they are welcome to do, given what we've seen here, that the questions need to be approved by the court before they go out. And the question certainly should not include the types of questions, fact-specific questions that have been delivered to 400 citizens of Latah County. That's where we're standing right now, Judge. Thank you.
Thank you. So then how can we compare unless you use the same questions? That's the problem. I mean, the damage has been done.
Well, that's one argument to make, but we don't want to perpetuate the damage that was done. And if they want to do a comparison, then they could have another survey in Latah County and do a responsible survey questionnaire instead of one tainting this people. And frankly, they should ensure that they don't go to the same phone numbers that they preloaded with this other factual information when they make their legitimate survey inquiries. The defense's people brought this on themselves. It's not the state's fault. Nobody had control over this other than the folks working for the defense. They made their bed. They got to live with it. I mean, frankly, if we were in the commercial context, we would say, not only will you do this over and do it correctly, but we will not pay you for the work you did that was so outrageously wrong. That's not the context right here. I don't care about that. What I care about is making sure that more people aren't tainted. And I would suspect, Judge, as we move forward in this case, that the state will be asking the defense, and if they aren't willing to provide it, asking the court to order the defense to provide the identity of every person that was contacted in those surveys. So when we get to voir dire, we can identify people who have been contacted, I guess is the best word to describe, and faced with these questions. And so we can incorporate that into the questions during voir dire to see just how much impact, if any, it had on each one of those particular jurors. I don't know how else to deal with this. I realize
disqualified 40 people.
Well, we 400.
400, that's what I meant. Sorry. Yeah,
400. And we could do that. You know, Lake Tahoe County has what, almost 40,000 residents, although not all of those are going to be part of the jury panels, prospective jury panels, but 400 may be a reasonably small number. And yes, I think that certainly would be a viable solution, is just identify those people. We can certainly identify them by telephone number it was called, and just not include them on the list.
Since you're standing up, you want to talk about due process?
Actually, Mr. Nye is the one prepared to talk about due process, and that's why he's on. He's available by Zoom. If you'd like to have that now, that would be good.
I'll come back to that.
Yes, sir. Thank you.
I'm concerned about that, Ms. Taylor. So go ahead, your turn.
Your Honor, we have Brian Edelman ready to testify by Zoom about these surveys if the court would hear his testimony.
First, I want to hear about the process. I care more about how this came down than what he did. Although I just learned for the first time that you had nothing to do with the questions.
I didn't write the questions, Judge. Those questions are generated by Brian Edelman, and he can tell you who he is and his educational background and why the questions are crafted as they're crafted. But I approved him doing this survey. This is not an anomaly. These kinds of surveys are done in high-profile cases quite often. I don't know how I could present to the court what's going to be required at the venue change hearing without understanding what is going on with the public. This is an anonymous survey. This is not one where anybody's identified as far as the defense wants to know this or the prosecutor wants to know this. It's a random survey, and there's a reason why there are general questions and more specific questions. And Mr. Edelman can explain that, but I'll do my best to paraphrase that.
Okay, well, I'm just curious. Did Mr. Edelman was he aware of the dissemination order?
I don't know if he was aware of that or not, but we gave him no information in the case, Your Honor. He received nothing from us as far as no police reports, no contact with our client, no interviews. He received no information. His entire construct of this survey is, as he does in his high-profile cases, he pulled the media local to this area to see what the most common stories were. Those are things that are in the public arena. This court and counsel knows how much coverage this case has received. And he does what he does by looking only at what's in the public. We didn't provide him any police reports. We didn't.
I'm sorry. It's just that does miss the point. I mean, it's kind of ironic that we have worked so hard, including you, okay, both sides, to protect a fair trial. Okay, and our concern from the very beginning was all the media stuff floating around, okay, that affects your client, Mr. Kohberger, to get a fair trial. And some of these questions actually create a concern about, well, that inculpatory. It could be prejudice for his client. Okay, and that I'm just surprised that both of you didn't come together and say, you know, there are certain things that we probably shouldn't put into the public on a telephone call. I mean, it really concerns me, and that's why I did what I did that Friday. Now I'm being accused of violating a due process, which is a whole big issue for me.
I can understand that that would not be taken. I have to represent my client to the best of my ability. And the reason for that, Your Honor, with all due respect, I was shocked to see the court issue an order within hours of the state filing a motion late on a Friday without giving us a chance to be heard. And that's going to delve into our argument on due process. But since it came up and since that feels like the elephant in the room right now, I think maybe we should just go ahead and address that.
Sure.
And that was my motion. And I asked you to set aside the order that you made without having a chance to hear from us, making a decision that now you're locked into. And it was a one-sided
I'm not
decision.
locked into anything. My order didn't say it was permanent.
Maybe
and it told you that I was going to have a hearing.
Maybe I phrased that very poorly. It's a decision that you already made.
Okay, let's go back. I got the motion at 4:30 on Friday. Now, it doesn't even reflect, you know, just when it was filed, because Odyssey has a delay, right? So I get the motion at 4:30 Friday. I get a response from you at 4:45 Friday, right?
I don't know what time you received it, but I filed an
That's when I
objection the
got it.
minute I could.
Because then you know that about 5 o'clock, that's when I issued that. So I had a half an hour. I read the materials that were attached to the motion that the state filed, and I had very little information. But it seemed like there were some real legitimate concerns about the survey. And obviously, it turns out there are concerns, legitimate concerns about what was done in the survey. So in my order, I told you that I was going to set a hearing. So I don't know what your understanding is with just the process. Okay, but I, on Friday, sent this hearing. So what are we doing today? Okay, I'm hearing you out. You had notice. I mean, really, that's what we're talking about. That's what the law. What is your understanding of due process?
My understanding is that I should have notice and an opportunity to be heard.
And you did that.
I'm having that now, but there has been a decision made by this court almost 2 weeks ago that stopped us from completing our work. I understand that Mr. Thompson raised a concern, and his last paragraph to the court in his motion was, it seems that it may have violated the non-dissemination order. And so we're stopped from completing our comparative surveys right there when we're up against the deadline to get to our motion to change a venue. I'm looking at, it stops me from doing the work and meeting the deadlines to argue for Bryan to be in a place where he can have a fair trial. I think the court should not have issued an order stopping us, but set a hearing, shorten time, set it for Monday morning. If the court wanted to set a hearing for that Monday morning, we wouldn't have lost 2 weeks worth of work if the court chooses to let us complete the work.
But that could have been more damage. I mean, you know, this less than 2 weeks really has very, very little impact, okay, on your work.
It does have an impact, Your Honor.
You don't even have a trial set.
We
I mean,
have-
come on.
We have our motion to change venue. We don't have trial. You're right. We don't have trial. My understanding was that we were going to hear the venue change and the court was going to make a decision and then set trial so that we didn't send out a bunch of subpoenas and reserve this courtroom unless we're going to stay here. That was my understanding. My problem, what sets me back, is getting my work complete to get my briefing to the state in the time and the deadline that I was already given, and meeting that hearing date that's set for venue change. And from there, everything else flows. When are we going to set trial?
We wouldn't even be here, okay, if there was some communication between you and the state about the survey.
There are things I can communicate with the state about, and there are things that I cannot communicate with the state about. How I'm preparing my case is not one of those things. It's just not one of those things. I go and see Bill and Ashley. I go to their office every week. Oftentimes we talk, we email each other, we talk to each other, but I don't need their permission every step of the way to prepare my case. Doing these surveys is not an anomaly. This is something that's done in these high-profile cases.
Well, apparently, Mr. Edelman did not even see the non-dissemination order, and you apparently did not give that to him. So this is a very not a usual case, number one. And you know that we've been working very, very hard to keep the sort of noise out of the case. And now it's been injected at least to these 400 people without a permission of the court, without discussion with the state. I mean, that's troubles me. And then when I'm being accused, directly accused, okay, by you in your brief, that I violated his due process rights. Now, that's not what the law says, and that's not what the facts are. And you even cited cases that say exactly what due process is in the law, right?
I understand that, and I agree that's what due process is. My issue is that the order was signed, stopping our work without a chance to be heard. It's as if the state and the court had decided we violated the non-dissemination order, and we didn't.
All I was doing was stalling it, okay, for less than 2 weeks so we could have this hearing, number one. Now, if you feel like you've been prejudiced or your client has been prejudiced for less than 2 weeks, okay, in this work, I'll push it out. I'll just push out the trial. I mean, not the trial, but the hearing. I mean, is that satisfactory?
Your Honor, I think that might be what we need.
Fine.
I need to figure out if we're going to be able to continue the surveys. But if we are, I expect that we will need some additional time to get them done so that I can get the work to the state to review.
Okay, well, that's a different issue. I've never said, no, you can't do a survey. This was a total shock to me that Friday at 4:30.
I can understand that. It was a shock to the
I had to
state.
stall it out, okay? Because so that we could all talk about it and figure out what is the right path. Okay, because this is a big deal and I take it very, very seriously. And I was surprised, okay, that this was happening behind our backs, my backs. Okay.
I understand that this probably is the first time this court has run into it. I know it was the first time that Mr. Thompson has run into it. I haven't used the survey in my own cases because I haven't had a case like Bryan's case before. This is an extremely high profile case. I've been involved in a lot of capital cases and I understand the standard of care in capital cases. I also know that this very kind of survey was used about 7 years ago in Kootenai County in another high profile case. I wasn't on the case, but I'm aware of it. I'm aware that this very survey has been used in other jurisdictions, other counties in Idaho and other states in really high profile cases. So I understand that it was a surprise to Mr. Thompson. He told me it was. And I'm hearing the court say that's a surprise as well.
It's how it was done. I'm not concerned. I figured there was going to be a survey at some point. There would have to be. It was the way it was done, okay, and the questions that were asked. That is the real problem, as Mr. Thompson pointed out.
So the way it was done, I know in the other Kootenai County case, permission to do the survey wasn't sought of the state, the prosecutor, or the judge. I can comment on that one. I know about that. I don't know about the other cases. So that takes us to why did we ask the questions we asked? I don't think it's common to get permission from the state to do our work. I think that it's a surprise because it's the first time that's happened, at least when this court's been on the bench and in Mr. Thompson's tenure here. So I understand that. When I met with Bill and Ashley in their office on the 21st, I asked them not to give you the police reports that they had in the transcript without me having a chance to be heard, because I didn't want an order without us being able to talk to the court. I asked if we could maybe set up an on-the-record meeting with the court to talk about this. And that wasn't what was done. It was Friday when this went out.
Sure. I mean, I would have been available on Friday to talk about it if that was necessary.
I would have gladly sat down. I didn't offer that next Friday. I would have come to town for it. I offered the following Thursday and Friday, knowing that I had a lot of availability both of those days. I would have come to town. I would have gladly sat down. By this point, the prosecutor knows I'm not telling him my preparation in the case, and I could have explained it. The thing I didn't want to happen is exactly what did happen. All of a sudden, there's an accusation against us and there's an order signed stopping us. I appreciate the court being willing to just push everything out 2 weeks. I think that's helpful. And I mean, if that's what the court's willing to do, that's fine. But the problem is we are stopped and then we have to respond to this. And if you think about the non-dissemination order, for sure, we wanted that non-dissemination order. We're the ones that asked for it. We're the ones that argued for it. We also know that our non-dissemination order mimics Idaho Rule of Professional Conduct 3.6. And when you look at that in the comments of that, I think it's helpful. There are things that we can say publicly, but we choose not to. Our team doesn't even so much as answer no comment to emails, to calls, to people trying to talk to us, because we just don't want to do that. It's easier to say nothing. So the construct of this survey is to ask these general questions. And then you ask specific ones because you get different answers when you ask those. It is not injecting information. They are, have you read, seen, or heard? And remember, these are anonymous and these are random. So they're not planned. Nobody's planned to be contacted. I don't know the names. I'm sure I can get the phone numbers if that's what the court wants. But I don't know who the people are. Nobody's identified as the person they're being called on behalf of, even when pressed by Detective Payne, that people conducting the survey didn't know. If we go back to the non-dissemination order, which mirrors Rule 3.6, that's to prevent lawyers involved in a case from making statements that will be widely disseminated, right? To talk to the press. And the purpose of that is because I read the police reports. I would have a little more credibility than anybody else on the street saying something about the case. Same with Bill. That's the purpose of it, so that we don't say things to the press on Dateline, on 48 hours, because we've actually read police reports, we've interviewed people, and we're doing the work on the case. So when you have an anonymous survey that doesn't identify the person conducting the survey, didn't know who was behind it as far as which party to the case, they can't answer that. So all of a sudden they're questioning about what you've seen in the media doesn't come from a particular party in the case. And the purpose of it is to ferret out what if people have exposure to the case. If you look at state's attachment B, you can see on page 2 that there's questions, and I'm at lines 10 through 12, about what they know about the case from the media. This is all, again, looking at our non-dissemination order and looking at the rule, things that are in the public record, right? That everything is public in this case unless we specifically seal it. So this person says they don't know much. And then if you go to page 4, there are several things they do know, and that's the purpose of it. When somebody's given a broad question, tell me what you know about this, they're like, I don't know. I don't really know what you want, so I'm not going to say anything. And they don't give you an answer. But when you say, have you read, seen, or heard X? Well, yeah. And then it's the next question. And if the answer is, no, I don't, it's next question. Nobody's saying, well, it was in the newspaper on 15 occasions. And this is particularly borne out when you think about the things, and the state said it, some of these things are things that are just not true. That's what the Haddon case tells me I have to show you. It's not enough that there's just a lot of media coverage, and it's a lot more harmful if it's media coverage about things that aren't true. So it's nobody's injecting anything into the case. A random small percentage of the population is contacted. Have you read, seen, or heard things that are lifted straight out of the media? And if the answer is yes, you move on. If the answer is no, you move on. That's what the survey was about. And you can see why looking at pages 2 and 4 of State's Exhibit B. And I think that we should also think about what the words in the non-dissemination order mean. When you say we disseminated information, that means to make widely available. This is a one-on-one conversation with no party identified. This isn't making it widely available. When you talk about disseminating information, the definition of that is to put it out there by public means, radio, TV, social media. And that's not what was happening either. These were questions. And they were things lifted 100% from the media, 100% already in the public record. And it is a one-by-one conversation. This isn't something that's being put out there through social.
Well, it kind of is.
Well, now it is, but I certainly didn't expect
400
this.
people, okay, it's planting some seeds where then people are encouraged, or they think, oh, wow, I didn't know that. I'm going to look more into this. I mean, again, we were trying to keep the false information that was out there in media land, that it wasn't going to affect your client.
I agree. This is less than 1% of the population. It's one-on-one. It's not by means of public communication. To think about alleging that we violated the non-dissemination order is basically alleging that we violated our ethical rules as well. And there's parts to it.
I'm not accusing you of that, especially now that I know that you that you didn't.
I didn't write the questions, but I knew what was going to happen. I take responsibility for the choices on the case, Judge, but I just don't think this is a violation of the ethical rules or non-dissemination order. These are questions about things already in the public record. That's in our order. That's in the rule.
Let me ask you this. I mean, really, getting hit by this on late on Friday afternoon, okay? I mean, I'm not sure what a judge should do in a situation like that, but I just say, yeah, no, keep going until we can have a hearing in 2 weeks or less than 2 weeks. Or do you just pause it down so that everybody can talk about it and figure out if there is an issue? That's how I looked at it from where I was sitting and what the information that was provided to me. And you did respond to it, but you said you were going to submit a brief and affidavit. That's great, but it was 5 o'clock on Friday.
I know.
So,
And I mean, I can't tell you how frustrating that was for me. I'd had this conversation with the prosecutor the day before. I'd offered to come and talk to the court and let the court look at all this. I knew full well if they did exactly what they did, the court would sign an order before I had a chance to say, hey, wait a minute. Let's really look at all of the words in the non-dissemination order. Let me tell you why we did this. I knew exactly what would happen. I don't want to say that there's like that you should do something different. I want to be heard on these things. I don't want the court to, on a Friday night, get a flurry of things that I can't respond to and ask you to think about the bigger context. We're lawyers, words mean something.
well, did you
Also,
think I wasn't going to give you an opportunity to be heard?
no, your order said I could be heard later, but there was a decision that was made then. And it's hard for me to wrap my head around the court taking this as an emergency motion when the words in the state's motion telling you put a stop to it are, it seems like they might have violated this. That is a weak accusation for the court to take an emergency order position on. But I know why the court did. The court has all of this and no context for it. And it's a Friday night. And I mean, if you'd received this on Thursday, my guess is you would have said, we're having a hearing Friday morning. I don't care if it's by Zoom.
Right. I told you all, both sides, you know, if you need to have a quick hearing, let me know. We can do it on Zoom. I mean, I want to move this thing along.
I
And
would
now
have
we're
been
spending
available.
all this energy, okay,
Yeah.
about this issue.
I lost a weekend of what I planned to respond to this. I thought we would probably be dealing with it on in chambers on the record meeting on the Thursday or Friday until I got the motion.
Yeah, I have about 7 briefs in now.
Well, you can see we lost a lot of time.
I'm not complaining about it because I'm learning a lot.
The last thing I'm going to say on this, Judge, is that non-dissemination order contemplates that you make this statement that you reasonably know is going to go out and harm the trial. This survey was never intended to do anything but identify issues within this county to support or defeat our argument for venue change. When you hear from Bryan Edelman, which I don't know if you have to now because I've said most of the things.
I'm happy to hear what he has to say if you want him to be said to me.
You would know, and you probably know from his affidavit, sometimes he recommends against venue change.
Sure.
Because it's not there. He's done with Latah County. The results aren't compiled yet. I anticipate he'll recommend we change venue. Where we are now is we'd like to finish the other 2 counties. You don't have to do 2.
You did say that he said that Latah County is biased.
I anticipate he's going to recommend we change venue for that reason.
I'm interested from him how he defines bias.
And
We all have some biases.
I will not put words in his mouth for that one.
I'm not expecting you to do that.
I will either have him testify today if you want to hear it today, or we'll do it at the venue change hearing when we get there. The question, I understand the court's willing to set our deadlines out 2 more weeks for venue issues. The question remains then, what do I need to show you? What do I need to present to you so that we can do a survey, a comparative survey? The target is 2 additional counties, and I really hate that I'm in here telling you all what we need to do, but here we are. So what we need to do is survey 2 additional counties. And I mean, we don't have to, we can come in with what we have, but generally I think courts ask, where could we go? And I think that's a fair question here, because we do know the media coverage has been extensive. And so I think it's fair to understand if there's a difference. If there's not, then you're left with
Are you going to tell me what counties?
I mean, I can. Do you want me to publicly disseminate that? Because this is the very definition of public dissemination.
I don't know if that should be done, or it seems like it could have some, whether or not there's some credibility about the survey, depending on what county you are looking at. We have very different counties and different thinking throughout the state. So I don't know what Mr. Edelman has in mind, or what you have in mind.
I can tell you, Your Honor, his recommendation is that we do one of the counties in Southeast Idaho because it's a different news feed and it's not on the front page of the paper every day. So we will do a Southeastern Idaho county. That would either be Bannock or Bonneville, and I think Bonneville is slightly bigger than Bannock. The other county is Ada, and the reason for Ada is because it has a very large courthouse with a lot of good security, and that court system has handled high-profile cases in a way that's safe for everybody. The population's very large there, so even if we had to draw off, a lot of jurors would have the population there to do it. Additionally, Ada County makes sense when you look at the Rule 21B, the convenience because of the airport and the number of out-of-town people that will be coming in, and the ability to have hotels and restaurants where there would be people wouldn't be running to other people necessarily. So Ada makes a lot of sense for a lot of reasons to me. Those reasons, the courthouse security and places to stay among them. But Mr. Edelman, Dr. Edelman has told us that because of the news feed that we really need to do a Southeastern Idaho. And so the decision was to do both. And in my mind, that is because it makes sense to know if we're going to go to the time to understand this and really give the court a picture, the court might want to know those two questions.
Thank you.
Sure. I don't think I have anything left to say right now.
Okay, thank you. All right, Mr. Thompson or Mr. Nye?
I'm not sure that the due process issue is something that's at issue right now.
I think I've already made this decision. I mean, based on the facts and the law. I mean,
There's no due process violation here.
no.
There is nothing wrong. In fact, law contemplates the court can take emergency action to stop something and call a timeout until it affords everybody the opportunity to have their say and the court can make the final decision. That is all Your Honor did here. And I would suggest, Judge, that it would not be prudent or proper for Your Honor to change or limit your own authority on that. I think that you have to continue to reserve to yourself the ability to act quickly, to cause a timeout if you are alarmed sufficiently to justify that, and to give the parties an opportunity to appear before you and sort it out. Before
I'm not going to change that. That's for sure, because the law allows me to do that.
Yes, sir.
And I know what due process means.
And I say that only in light of an email that your staff attorney sent to us the other day ago that suggested that maybe the court was not going to be entering orders without full hearings with everybody.
Oh, well, but Ms. Taylor wanted, she said, from here on out, we're going to talk about that too. Because now I understand, because I haven't seen it yet, because I didn't have a computer, that you are stipulating to sealing all the discovery stuff. And I just stopped, okay, in terms of signing on those orders that you're sending me, because I don't want to be accused of doing the wrong thing. And there's another situation that you brought up, Ms. Taylor, about that there was a prior thing where I had done that about the IPD.
Yep.
And the state asked to do a public order, just to say that we provided the IDG or some of the IDG to you. And that doesn't really say anything except that. But you were criticizing me for that too.
Your Honor, to be clear, it's not the content of that order. My concern is the process. My concern is it feels like from our perspective that Mr. Thompson says, hey, judge, can you do this? And I'm getting ready to weigh in and it gets done.
But you didn't, I didn't get a response from you.
Your Honor, that was out the same day. I was in the process of writing, and this was by letter. It wasn't by motion. I was in the process of writing a letter to the court asking to be heard on some issues, and the order was signed, or the new order was generated. The content of it isn't the problem. It's the concern about the process, the concern about making sure we have a clear record of what's done, and the concern about things halting what we're doing before we can be heard. And
Okay, did you want that to be not sealed?
No.
The other part, all the IGB stuff, that's like 6 pages, 7 pages?
No, Your Honor, I don't have a problem with what the court ended up doing. I was concerned about the process. And then having this order issue on a Friday without having an opportunity to talk about it, my alarm bells go off. And I think this can't happen. I probably have the court's attention squarely on me in this issue, which I anticipated, but what I didn't want to have is I don't want to have the prosecutor writing the court letters and the court doing something and me running around trying to catch up. I mean, the thing that happened is fine, but then we have this other thing that happened, and I don't want this habit. I understand. I'm sorry.
The survey. That's what.
Yeah, the order to stop. Yeah.
Sure.
So it's that there are 2 things that have happened without me being able to even weigh in that's done when the prosecutor asks you to do something. And I don't like that. I want to have opportunities to be heard. I certainly understand a court's emergency power, but if this was an emergency, the state knew from March 8th about these surveys. The state sat down and talked to me, and I offered to see you with the state. And then their motion said, it seems like it might be a violation. So I think maybe we need to define emergency a little bit better, because I know you have those powers and I wouldn't ask you to not use the powers that you have. I think the problem here is the way this gets presented when there were a lot of different roads and it cuts us off. And that's what I don't want to have happen.
Okay, I want to solve this problem if it's possible. One of the things, I mean, because you have filed motions where you didn't ask for a hearing. There's still one, couple hanging out there. Okay, and so I don't know if I'm waiting. Okay, if you're asking for a hearing or not, or if because historically you guys have worked really well together. Okay, stipulations, but then I don't get a stipulation. I don't get a request for a hearing. So what am I supposed to do then? So what I'm starting to wonder about is maybe we should just have a hearing, okay, at least once a week. I mean, a month, maybe once a week.
I'm here every week.
Maybe
You can do it.
Okay,
you can do it.
Like a Thursday afternoon. Okay,
That's the day I'm here.
and then, okay, so and then we can kind of clean out a lot of these things that are sealed, or arguments about this or that. I don't particularly want to do that, but you and the court, okay, both of you, I say you, both sides, that you worked really hard, okay, to protect the goal of a fair trial. And all of a sudden I feel like it's cracking a little bit, the work together, okay? Because if we have to have hearings on every single thing, we got a long ways to go. And it's a lot of time, it's a lot of work, it's a lot of money, and it just makes everything more difficult. So if you can come together on certain things, then it's a stipulation that we need, then it's a stipulation. If it's a hearing, it needs a hearing. I'm fine with accommodating whatever needs to happen in short notice too.
because, like I said before, I just want to keep moving on this. Just so taking a long time.
Your Honor, I think the record shows that we have been able to stipulate probably to the majority of things. I don't keep count. There are some issues that we have not been able to reach an agreement on. And bringing it back to the issues that are before the court right now, I realize we have a bigger picture to talk about. But the defense makes a big deal about the state hearing that there was these surveys. There were surveys going on in our community back in around the 8th or so of March. And as the declaration that's been filed with the court shows, yes, we did. And we immediately referred that to law enforcement to investigate, find out what these surveys are about, find out who these people are that are doing the survey if you can, get that information to us. And that process is in the works. And just days before we were able to meet with Ms. Taylor on the 21st of March, just days before, we got the reports from the police department, and we also got that recording. That, frankly, the recording is the icebreaker on this. It's the game changer because it's literally what was being said, what was being asked, what was being represented in the form of the question. Ms. Jennings called, reached out to Ms. Taylor, say, do you know anything about this survey? Ms. Taylor says, yes, I'll be in town on Thursday. How about we talk about it? Okay, so we sat and waited. I can tell you, I suspected that this was something that the defense had commissioned from the first we heard of it. But I didn't feel that we had enough information about the nature of the survey to determine whether it was problematic. And we've said this already, and it keeps getting missed in the arguments here. We don't care about surveys. We care about these particular questions asked in this particular survey. The defense is welcome to contract with people from California or wherever, I don't care, to go and ask people, can you be fair? What have you heard about this? All of those questions that Ms. Taylor was just talking about at page 2 of the transcript, those are appropriate questions for a survey. Page 4 are not appropriate questions for a survey. Just because they're put in the form of the question doesn't change the fact that they are an affirmative representation of a fact that if the hearer, the listener, was not aware of it, now they have been tainted by it. They have been, in your Honor's words, they have been injected with that information. That is a clear violation of the non-dissemination order. To think there's a distinction between putting something out in a press release and talking to a private citizen is a distinction without substance. Those are both public contacts. And I can guarantee that if I went down to the bar and had a few drinks and was talking with some people and say, hey, did you know this about the Kohberger case? And the defense found out about it, they would go ballistic. And for good reason. That should never happen. But that's exactly what's happened here. Not by Ms. Taylor. I'm not faulting Ms. Taylor for the questions themselves, but by the people they hired to do this. And it had to stop. Your Honor was absolutely correct. Cut it off. And let's sort this thing out. And if we lose 2 weeks, well, we can make up 2 weeks. Your decision was perfectly appropriate. For the defense to claim that there's some due process violation there is without any legal basis. The defense's objection is, we don't like it, Judge. Well, there's lots of things that happen in court that I haven't liked, not in this court.
Well, probably a few.
Well, maybe with your Honor in other cases outside. That happens. That's part of the game.
I'm not here to.
But just because somebody complains doesn't mean that it's legally wrong, and there is no due process violation here. And Mr. Knight is prepared to argue due process minutiae if that's what we want. But I don't think we need to deal with that. We are dealing with the issue of these questions in the survey. They are completely inappropriate. We have a group of at least 400 people in Lake Tahoe County who have been exposed to this in violation of the non-dissemination order. I think your Honor is probably right. The only way we can deal with, or the best way to deal with that, would be to exclude them from any prospective jury pool. But we sure as heck don't want to say to the defense's consultants, yes, go do this in other venues as well, where if we can't pick a jury here in Lake Tahoe County, we may have to go to. Go ahead and mess with them too. That's ridiculous. I do not question the right of the defense to commission surveys, responsible, proper surveys, as part of the debate over venue. But this survey cannot stand. If they are going to do that, they need to start from scratch if they want to compare it to Lake Tahoe County. There is no way to take the 400 responses that have been loaded with these factual representations in the form of questions. There's no way that that can fairly be compared to surveys without those questions anywhere else. It's apples and oranges. And yes, it may be an expense, and it may be a delay of time, and it may be an inconvenience, but it is not of the state's making. It is entirely the responsibility and the fault of the agents of the defense. Entirely. We don't care if there's a survey. Now, I'll keep saying that because we keep hearing from the defense that we don't do surveys in Lake Tahoe County. That's not the issue. We know a survey is going to happen here. Now, when it comes to this idea of what happened 2 weeks ago, when we met with Ms. Taylor, we said, Ms. Taylor, no, actually I said Ann. We gave her the information. We talked about it. She indicated she wasn't aware of the actual questions. We said, we are very concerned about this. This needs to stop. And the response, if I remember, was along the lines of, well, we think they're about done in Lake Tahoe County anyway. I said, well, we need to bring this to the court's attention. Here's my proposal. We will send a letter to Judge with these attached, copy to you, and then we can have a discussion. And I was told no. The defense did not want, Your Honor, to see this without also having whatever they wanted to offer in response to it as well. I said, well, that's not how it works. I mean, we'll file a motion. Normal law practice. I've been practicing for 43 years. I lose count now. You know, if you can't resolve something, you file a motion with the court. If there are things you want to base your motion on, you attach them to the motion, and we proceed from there. And so that's where we left it. Ms. Taylor did say, well, I could be available the following Friday, Thursday or Friday, to talk with Judge. And to my mind, well, that's too little, too late. As far as we know, these surveys are going on again right now, wrapping up or starting somewhere else, whatever. It needed to be addressed quickly, not wait a week to have a conversation and then go into a conversation where you're left cold. We walk in the door and we aren't able to provide you the basis for our concerns. So you are completely helpless with information. That's not how it works. That's not how informed decisions are made. So we prepared a motion. We made the attachments. We filed it mid-afternoon, early mid-afternoon, not late in the day as it's characterized here. Now, I appreciate that Your Honor didn't see it till later in the day.
Right.
But that wasn't the intent. The intent was to get it filed as quickly as we could. There was no scheme to do some, 5 minutes to 5 o'clock filing and take some advantage of the defense. That's not the way we do business. That's not the way I do business. And frankly, it's a little offensive to have that suggestion made, but I'm going to move beyond that. I have to say, I am disappointed to learn today that Dr. Edelman and his associates were not made privy to the non-dissemination order. But we can't undo that. And once again, that's not of the state's making. My knowledge, everybody that has been asked to take actions of any type on behalf of the state has been made aware of those restrictions because they are our agents. And we know we are responsible under the court's order for the actions of our agents. Regardless, I'm disappointed. I also want to be clear that I'm not standing here today making a bar association ethical complaint against any member of the defense team. Yes, language in the non-dissemination order contains language that parrots the Idaho rules of professional conduct, but the laundry list of things that the court lists, I think, are much more specific. And that's what we're concerned about. And if I'm wrong and those are in the comments, well, then maybe there's a violation of that rule, but that's not my interest. I have no interest in doing that. My interest is in taking care of this case, making sure that we can have a fair trial, making sure that Your Honor's non-dissemination order is honored. And at this point, trying to figure out a way to cure what has happened. The first thing to do is we have to say, Your Honor, court needs to say, no, you will not ask any more questions of prospective jurors without the court approving it. Because we've seen that the people retained by the defense cannot be trusted in that regard. Fools once, shame on you. Fools twice, shame on us. We don't want to get into that. They wish to proceed with surveys, they can, but they need to start over.
Start over in Latah County.
Yes, sir. Absolutely. Absolutely. There's no other way to get a fair comparison with any other prospective veneer without doing a new survey in Latah County and not including any of the people who were surveyed in this 400-person group. That's the only way we can avoid this taint. Again, this is not of the state's making. We are trying to salvage a mess. As Your Honor noted, there's no difference between talking, and I said just a little bit, talking one-on-one and issuing a press release or standing down in Friendship Square with a bullhorn. The dissemination is dissemination to a member of the public, and it's equally in violation of the no contact order or the non-dissemination order.
Do you think some of those 400 people might have talked to other people, like their families?
I know
their friends.
I know they have, Judge, and the reason I know that is we got a call from the sheriff's office earlier today where a woman called and said that she had heard about this survey and the survey made her uncomfortable. And when they called her back, it actually was her son that had received the survey inquiries a couple of weeks ago and happened to mention it to her. And she just wanted the sheriff's office to know about that. I mean, we have good, responsible people in this county, and they can sense what's right and what's wrong. You don't have to be a trained lawyer to know that it's not right to go out asking these kind of questions to people who might be prospective jurors in the case. It's just not right. So that's what we need to do today, Judge. I don't believe there's a due process issue. Matter of fact, I know there's no legal due process issue here. I appreciate Ms. Taylor isn't happy with the things ready to roll out. That's life sometimes. But there's no due process issue here. And we ask that Your Honor enter the order, cutting off any more use of this survey, directing that that the defense, if they wish to continue with the survey, start over and submit questions to the court to make sure that we aren't getting ourselves back into a similar situation, baiting people who may have no knowledge of this case with detailed information, and detailed information, some of which is completely false. And not only completely false, but it's false in a sense that makes Mr. Kohberger look bad. It is creating bias against Mr. Kohberger based on false or inadmissible evidence. That's outrageous. How can we possibly preserve a jury pool when that's going on? We can't. It has to stop. Thanks, Judge.
Mr. Thompson, Ms. Taylor.
So not liking the result of a hearing or not liking an order from the court is one thing. That happens all the time. I think courts probably have people on both sides of the aisle that don't like whatever decision they make most of the time. And that's just the way it goes. What I complained about was not being able to have a voice before a decision was made. I think that's an important distinction. I'm not saying don't make a decision I don't like or I'll file a motion against you. I'm not saying that at all. I imagine over the course of this case, there will be decisions I like and decisions I don't. It's the way it's been in the past. This was solely about being shut out of the process before a decision was made. I understand the order said I could have my day. Here's my day. So that I want to make it clear. It's that motion didn't come because I didn't like the result. I didn't like the process. That was it.
That was my issue too. The process.
And I wanted to be heard about that. I do not think that these survey questions that related to what have you heard in the media injected information to people. I understand that this is a close community, and I understand that people will call officers with concerns and the prosecutor with concerns, and that's kind of the point. That's kind of the thing that I'm worried about is the close-knit nature of it. That's a good thing unless you are an outsider having a trial, and then it's not a good thing. And that is kind of a problem that we have with that.
Well, I can tell you from my own experience, people I see that there's plenty of people here who really don't like law enforcement that much. So I think it's always a mistake to stereotype people or communities.
Fair enough, Judge. Usually I don't find that people that have issues with law enforcement make their way to my juries, but that's probably something we'll talk about a different day.
Sure.
As far as where we go from here, the moment of getting our work done and not having it out in public is over. So I suppose the court can weigh in on what we should do. I wouldn't be quick to say that we couldn't use the surveys that were done. I would, if that's the route the court is going to go to have us do other surveys. I mean, that's what we'll do if the court asks us to do that. But I'd ask the court to remember that it's quite common for the general questions to draw a no. And then you ask other questions because then people are like, well, yeah, I did know that. And that's how you get to the heart of the real information. So I think there's got to be some give and take in there. I'll say two more things and then I'll be done. Our office did send Dr. Edelman a copy of the non-dissemination order. I didn't know he didn't receive it, but he didn't receive it. He definitely knows about it now. I would have caught that, but we didn't send him anything. Our process is to make sure that we have the signed order back from anybody that we're going to communicate with about the case. This solely had to do with him looking at what are the media stories, what are the big topics, so I can determine how saturated the community is and bias it. So that's why I didn't catch it. I'll take responsibility for that. But just to maybe allay some of Mr. Thompson's disappointment, it was sent. I don't know what happened, but he didn't receive it. He's sure this was. My other thing is if the court wants to change the survey, I would like an opportunity to speak with Dr. Edelman about the possibility of preserving what we've done versus just starting all over before, I guess, any more surveys went out if they're going to be changed. If the court will let us keep going with the way we're going, then we could make the comparisons from county to county. But if that's not what the court's going to do, I would like to see if there's a way to preserve what's been done by not looking at the questions that the court wouldn't want us to ask of other jurors. And I don't know if that works, so I need to talk to Dr. Hill.
Yeah, that's what I'm kind of interested in, trying to figure out. And we have to start all over, how to approach this. And I mean, one of the things that I'm concerned about is how much this costs taxpayers' money. And I have no idea. I'm not part of the money, part of this. But if there's a way to kind of salvage something. I'm not happy about these specific questions, especially ones that are false. Then people hear that and they just get even worse sort of impression. Okay, Mr. COVID. There are also cases that are questions that are very specific that are going to be major issues in the trial. And so I'm really worried about that, particularly, again, I think this, I said this earlier, it's kind of ironic that, you know, this with the time, the passage of time has kind of calmed down, you know, in terms of the media and very heavy initially. I have to say that to be here today, but the streaming has probably helped a little bit. Sort of kind of slowed things down intentionally, but I think people kind of move on a little bit, and then all of a sudden they get a phone call from a stranger talking about particular issues in Kohberger case, and so it kind of fires it up. And that's one of my worries. Also, just the fact that you can say 400 people, but 400 people in town spreads really thin. So it is dissemination. And I'm no expert about it. I don't know if I think you probably should. Mr. Edelman is going to hear this whole hearing, so maybe a discussion with him, maybe even a discussion with each other. Everything's kind of out in the open.
Sure.
I'm very grateful. I'm very grateful for that because I like to know to some degree what's happening in this case. And let's just deal with it really quickly. I don't know, maybe we can next week.
Judge, I plan to be in town on the 11th. If the court wants a hearing, I can make myself available really any day next week. I already have plans for the 11th, but I can be available any other day the court wants.
So I'm going to be sitting with the Supreme Court in Nez County. So could you maybe have a hearing, short hearing of some kind, maybe on April 10th? Or
Your Honor, is that a Wednesday?
yeah, that's a Wednesday.
I will if that's the only time the court has. Wednesdays, I have different things, but I can cancel them if that's the only time. If the court wants me to come back Monday,
I'll work
I can.
with you.
I could, 3 o'clock in the afternoon would be easiest for me on that day. On the 10th.
I have a treatment court meeting 2:30 to 3:30.
I can do 4 o'clock, or if the court wants to do it at 1, I can make that happen too.
Judge, I'm confused. What are we gonna have a hearing on?
Well, I want to see what thoughts you all have about dealing with the situation now, making sure that we can salvage anything or nothing. And Ms. Taylor's going to talk to Mr. Edelman, and maybe that'll give us some thoughts. Otherwise, I mean, I could just make the decision right now, but I'm no expert about surveys.
I understand. Thank you.
So I don't know how you feel about 4 o'clock on April 10. Could we just do that by Zoom, or do you want to be here?
Your Honor, Zoom would be fine with me. Mr. Kohberger would likely not be present. If he's present by Zoom, I will be here with him. So,
okay, I mean, well, we can do it in person.
let's go ahead and do it in person. I'll change my visiting day to Wednesday instead of Thursday.
Okay. Is that okay, Mr. Thompson?
Yes, sir. We can be here 10th, 4 o'clock.
And, you know, Ms. Massif or Mr. Nye or Ms. Beatty can participate by Zoom.
Thank you. Yes, sir. Thank you.
I'm just going to pause. Is that date good for you guys? I'm going to get back to it. We're not missing anything. I just want to welcome Spirit Walker, our new channel member. And Wicked is a new channel member. Jane gifted a reporter room membership. Thank you so much. And Jazz, thank you for the super sticker. And thank you also for this super sticker. Very, very kind of you. And I thought I had one more channel member that I saw. I don't see them now, but we'll go back to it, and then I will look for their comment.
Because I want to make the best decision I can, if that's possible. Okay. Let's talk again about, you know, having a hearing at least every month. It's just like cleaning up. And also, I guess you just did have a stipulation that you filed, but I have some. There it is. There's pending the state's motion to temporarily seal Exhibit 1 in the state's response to defendant's 12th supplemental request for discovery.
I want to welcome Hippie. I'm so sorry I missed you as a new channel member. You were like one of the first ones, and I thought I started, but I didn't. So welcome to Reporter Room. Okay, let's get back to the hearing, guys. So glad you guys are here. If you want to be channel members, we're not missing anything. I paused it, but if you would like to, it's next to the join button. But subscribing helps a lot also.
That
would be covered by the stipulation that we filed today.
Yeah.
okay?
The goal with that, Your Honor, is we often want to file those attachments to discovery under seal. Those contain things that shouldn't be made public. We both agree to it. And originally we were getting stipulations. And then I think we've done it so much, we just started doing orders. So the purpose of that is for us to just send along those and with an order for under seal, knowing that I'm always going to stipulate to attachments to discovery responses to be under seal, and the same with them. I mean, we know what we're each asking. So.
Okay, and I worry about the clerks too. Okay, so if you could just have a stipulation that says, with regard to discovery responses, you can go ahead and see. Okay, I mean, as long as it's justified.
And that's the intent of what we submitted today, Your Honor, is that attachments to discovery requests and discovery responses, not the cover document itself, but the attachments that have the details would just automatically be sealed when we're stipulating to that. So that would be routine.
Okay, great. So you backed off a little bit there, Taylor, Ms. Taylor, in that particular, you want everything, a hearing, or, you know, everything needs to be stipulated.
That is a stipulation, Judge.
Well, it is, okay.
We also, Judge, I believe we have some other things on the motion to augment the record. We've been gathering more information on that, and it's my fault that I dropped the ball last month and didn't get a second batch of information compiled to Ms. Taylor. She got that today. We are contemplating that we will be able to present the court with a stipulation on that issue as well, with certain emails and communications attached to it, and then also have an ongoing stipulation about off the record communications, email or letter communications involving the court.
Excellent.
So we're making progress. We're working together on as much as we can.
There was also a defendant's motion requesting additional deadlines that was filed on March 6th. We didn't ask for here.
Your Honor, I haven't asked for a hearing. I know the state filed an objection to that, and we don't have a hearing on that yet. My thought would be that after we submit everything on our motion for venue change, when the court's ready to make a decision on that, I think that's when.
You guys aren't missing anything. I just want to welcome Amber as a new channel member. So glad you are with us, Amber. Welcome.
Would probably call for a hearing on our motion, and probably the state would want to be heard at the same time on their objection.
Okay, so that can just, hang out there for a while.
I think so.
Okay. Then we got state's motion to unseal. State's motion for order of prohibiting contact with the prospective jurors absent leave of.
Which is relates to what we've been talking about today, Judge.
Yes, I know.
We had filed our original motion under seal. The initial response from the defense was under seal that said we object. And then the defense's memorandum with the attached affidavit was not filed under seal. So our position was that in fairness to the public record, that our motion should be unsealed and just keep the attachment sealed to protect the identity of the people who were interviewed by law enforcement or contacted law enforcement about being subject to the survey.
Any objections, Taylor?
In large part, no. There is a sentence in there where the state talks about evidence they plan to present, and that would seem like something they may want redacted before it became in the public record. Our response didn't have anything like that. I can show Mr. Thompson later, so in case he wants to prepare a redacted one for the board.
You know what she's talking about?
I don't, but we can talk about it, Judge, and Ms. Taylor can just show us or send us what the language is. I'm sure we can work it out.
Okay, and so, and I guess this, we are already covered by the stipulation, defendant's motion to file exhibit and attached to defendant's 14 supplemental requests for discovery.
That would be covered by today's stipulation.
Okay. Okay, I think I've had my speech, so.
Thank you, Your Honor.
So we don't need to hear from Mr. Nye or Mr. Edelman at this point.
I don't believe so. I think that it may be more prudent for Ms. Taylor and Mr. Edelman to talk between themselves first. And I believe the due process issue that Mr. Nye was prepared to discuss has been resolved.
Okay, I have no doubt that I did not violate due process rights
Yes, sir.
of Mr. Kohberger.
Yes, sir. Thank you.
Okay, anything else, Ms. Taylor?
Not today, Your Honor. Thank you.
Okay, great. We are adjourned. Thank you all. Thank you for your patience.
Thank you, Your Honor.
Y'all didn't miss anything. He didn't turn off his feed. But I'll be more mindful of that moving forward, Viv. All right. Wow. Wow, that was like just absolutely bonkers, you guys. So the judge was furious. He was absolutely furious. So let's take a look at why was he so upset. Let me grab this. Because Ann Taylor went after him and the prosecutor publicly, making out that they were somehow colluding together. She was way out of bounds. Let's see if I can find her comments. I had them pulled up. I did it at the beginning, but so we know that Bill Thompson requested the judge's order in a motion filed under seal. So on March 22nd, so the judge found out about this on like the end of the day on a Friday. He reached out to Ann Taylor. She answered him back, and he wrote a very short order saying both parties are prohibited from contacting potential jurors about this case via third party until further order from the court. And he says, quote, a hearing on this issue will be held as soon as practical. And he did. He held a hearing, within 2 weeks. But Ann Taylor went after him in the public, and this is why I think this is why he was just so upset. It wasn't just that she went behind his back on the survey. It was that she maligned him by trying to imply that somehow he was colluding with the prosecution because she didn't let them continue let them continue the survey. And I think, I think she got her headline out there. All she needs is one juror, but I don't know at what cost it was because she didn't get her change of venue. That's what she came in wanting. And she didn't get that. And we didn't get a court date. That's what we came in wanting, right? We wanted just a court date. But it was absolutely bonkers, everything that went down. Wow, I think that's been probably the best hearing that we've had on this case. So the problem that the prosecution had with these surveys were the questions that were reportedly spreading misinformation or disinformation or saying things that weren't going to be allowed into the trial or that were going to be allowed into the trial, but were under the gag order. So she says she didn't know what the questions were going to be. And I believe her, but I also believe that she said, I don't want to know, don't tell me. So she could be able to say that at the end, because they always say it's easier to ask for forgiveness than to get, it's easier to ask for forgiveness than permission. She went behind the judge's back on this. He was really upset. So juror misinformation, this can plant preconceived notions into a potential jury pool. And some of you guys were making the point in the chat that, yeah, we don't know who they're going to talk to and share this misinformation, disinformation, or information they're not supposed to have at all. And then Ann Taylor still wanted to use this survey to put in for a change of venue, but the judge wasn't having it. They're going to make her redo the survey after he approves the questions. So he didn't have a problem with her doing the survey. What he had a problem with was that she went behind his back. She didn't get approval from the judge for the questions that were being asked. And there was stuff being asked to the point where more than one juror contacted the police. It was a recorded call that was singular, but reports was plural, like multiple people contacted the law enforcement because the questions set off alarms for them. I wish we could know what those questions are. So the judge shut down Ann Taylor, and no one is to reach out to prospective jurors. This includes the prosecution. And I think if Bethany and Dylan, the two roommates, have to sit quietly while their names are being dragged through the mud, then the least, and this is all to protect Bryan Kohberger's right to a fair trial, the least the defense could do is do the same thing. What did you guys think about all of this? Let's take a couple of comments. Jane says, yes, she did go behind the judge's back. Not smart. Can't she be reprimanded? I think she kind of was. I mean, I feel like he did kind of, let her know. Yeah, girlfriend is like, wow. I think we were all just sitting there with our mouths open, like, wow, I can't believe it. Mike, I did see your question. Did she go behind the back? Yeah, she did. She decided it would be easier to ask for forgiveness than permission, but now she can't use her survey. And now the prosecution wants to know the phone numbers of who she called, and they're going to use those phone numbers in voir dire. Whew. Mike agrees. Mike, you were asking earlier. I'm sorry I didn't answer you. I just didn't want to interrupt because it was just so much going on. You were asking, how do you get a check mark by your name? That's channel member. You hit the join button, which is next to the subscribe button. But subscribing helps me a lot too, you guys. It's free. Kimmy is exactly. Hey, Marty. Marty says, well, I guess what I surmise is that Ann Taylor is a gutsy person. Yeah. Kimmy thinks she should have been fined. Kimmy says she snapped back. She came with audacity. Cravid's music says pure insanity. How did she think she would get away with it? I don't know. I don't know. I mean, she did get away with it, sort of, except she didn't get to use her survey. And she made the judge, I mean, that's as mad as I've ever seen this judge. I've never seen Judge John Judge, get mad. If you guys are coming in late, you can back up the live stream and watch it. This was fireworks. If you're just getting off work and you're just coming in, yeah, Marty's like, what a cluster. Yeah, that's a nice way to put it. Cheryl wants to know, how is she not being fined by the court? I don't know. Maybe he will privately. Maybe he doesn't want to do it publicly, or maybe not. But I did feel like she got in trouble. She didn't just do that. She went after the judge and the prosecution in the media, and made basically smear accusations. Viv says it's not so much going behind the judge's back as knowing those questions were out of bound, in my opinion. Yeah, I mean, she should have let the judge know she was doing the survey, and then he would have, of course, asked to see the questions. But now she's been able to get her questions out to 400 jurors. Jane says, I think the judge was reprimanded by her quite a bit. Yeah, he was. I wish he would have just set the court date. Set the trial date. I just wish he would have set that trial date. I thought we would have one for sure. Now we're having weekly hearings. And if you don't know, we're doing the Chad Daybell case, and we're going to be streaming it here on Reporter Room. So I don't know how I'm going to handle it if I have a hearing in the Chad Daybell case. I might have to get another computer set up here. Hey, Mark. Well, Mark, you can back up the live stream because, man, oh man, you are definitely going to want to watch this hearing. Woo! Woo! The judge, that is as furious as I have ever seen Judge John Judge. Ever, ever, ever. And basically called out Ann Taylor for not doing right by Bryan Kohberger. And last hearing, she let it slip that it was his car. I don't know. If I were him, and he looked like, surprised that, or maybe it was the prosecution that said she wasn't doing right by Bryan. He looked really surprised, but I don't know if he realizes the gag order is for his own protection. I'm sure he must know. Yeah, rewind it, Yvonne, watch it. You can, it's definitely worth watching. Micro Kimmy says she knew better. She knew what she was doing. I think she knew too. And I think she thought she would get the trial moved. I think she thought she would get to, despite all of this, she would throw the prosecution and Judge John Judge under the bus in the media, back over them, and that she was going to get out of this with clean hands. No, she didn't. She's not getting to use this survey. He's going to make her do another survey. And they want all the phone numbers so that when they are doing voir dire, they can figure out which jurors, if any of them make it into that final 50 for their voir dire, they can, find out what they know. Kimmy says she took a calculated risk. I don't know if it was worth it or not. I don't know, because she didn't get what she wanted. What she wanted was a change of venue. She didn't get that. He wasn't giving her that. Yeah, welcome, Mark. Yeah, back it on up. Kimmy says enough tainting would force a change of venue, which is what she wants. Yeah, I think that was the goal, but the judge wasn't having it. He was like, nope, we'll get the phone numbers of everybody you called. I want the phone numbers, and you're going to do the survey again. So yeah, she did create a quagmire. She made her own bed. Unfortunately, the thing that's really sad about it is that Bryan Kohberger has to lie in that bed too. And this is the second hearing that I feel like she put her own, what she wanted, ahead of him. And last time it was a slip up. It was just, a human error. We're all human. We make mistakes. And she let it slide out that it was his car. She admitted it in the last hearing. And on this one, she was trying to get the change of venue, and she didn't get it. I don't think she's going to get it. I'll be very surprised if she gets a change of venue at this point. Maybe he'll calm down, but he wasn't doing it today. She had her guy that did the survey ready to testify, and the judge didn't want to hear it. Create Vids Music says, I would not want Ann Taylor on my team. Yikes. I feel bad for Bryan Kohberger. I don't feel bad for him because I do think that, I mean, this gag order is in place to protect him. So she was trying to do a change of venue to help him, but what she did was alienate the judge, in my opinion. I think by accusing him of basically colluding with the prosecution, he was furious. It was in the media. Yeah, and Jess is like, yeah, back up. You can back up any live stream. You can back it up and watch it. There were fireworks today. If you missed today's hearing, please go back and watch it. You will want to catch up. You'll want to see it with your own eyes. At least the first hour of it. Oh my gosh. Penny says, when you listen to her, you can catch her lies. Yeah. People kept telling me in the comment section, she wouldn't lie about this or that. Now it just makes me wonder, what else is she lying to us about? Is there no DNA in the office, the car, or the house of Bryan Kohberger, or that she didn't find it? Because remember, she didn't have everything when she made that claim. Or is there really no DNA in those areas, except for the knife sheath, of course? I don't know, but man, she was backpedaling today. Jane says, if Karen went after the judge, then she wants him replaced. She may be. I don't think he's gonna. I mean, she went to the Supreme Court to try to go over his head on the grand jury thing after he ruled the third time that he wasn't throwing out the indictment, because she wants to change the rule of law to make it beyond a reasonable doubt, which is a trial. We might as well have a trial. But no state in the United States has a grand jury indictment beyond a reasonable doubt. That's why we have a trial. It's just, is there enough evidence to indict him? So, woo. But he was very, very, I mean, I thought he kept his cool pretty well, but you could tell he was hot. He was hot. Cheryl's like, I'll be rewatching this. I'm going to watch it again too, because I know there's stuff that in the heat of the moment, like on the last hearing I watched it, I didn't catch that she admitted it was Bryan's car till I went back to rewatch it. And I was going back to rewatch to just pick up any little things that I might have missed. And I saw that and I was like, what? Hold on. I backed it up and I'm like, what? I like replayed it for myself multiple times. I just couldn't believe that she admitted that it was his car. She did not do him any favors. I thought, if, I know there's only a couple of them that are capital. I think there's 17 attorneys in the state of Idaho that are capital punishment certified. And I'm sure at least one of them is on the Chad Daybell case, which is also in Idaho, which we're going to be watching together. And I'd watch stuff. I watch it without talking. I just want you guys to know that if I say we're watching something, we're watching it. Because I hate it when I'm trying to watch a trial and then I have somebody in there talking over stuff. I don't mind reactions or sharing comments while I'm watching, but I really hate it when somebody's talking over what I'm trying to listen to. If they pause it, I don't mind too much, but if they're talking over testimony and I'm trying to hear a witness, it really, really, it bothers me. So yeah, back it up, because woo, it's worth, if you're going to watch any hearing, this is the one to watch. And then last week or 2 weeks ago, when she admitted that it was his car, we didn't catch it. I'm sure there's stuff in this hearing that I didn't catch it. I'm going to be rewatching this as well. Mike says, I hope the judge gets a better camera. I think that's it, Mike. I think this is what we're going to get. I wish. I enjoyed the judge putting her in her place, Angie says. And Jess says, I agree. It's a bit blurry. That was Ann Taylor too. She did not want any close-ups of Bryan Kohberger. She said that the media was trying to zoom in on his fly. I didn't see anything like that. They were getting close-ups of his face and his facial expression. And, maybe his facial expression is inappropriate and that's why she doesn't want it on him. Or maybe, I don't know. But that was her choice. She made that decision also. So you guys, at least we were getting a camera. At least we're getting something. Lori Daybell, we got nothing. We got an audio. So at least we're getting a camera in there. And for Chad Daybell, we also have a camera. Jane says, I meant to say the judge reprimanded her. I had typos. I made a typo too. I think I was supposed to say not, and I left the word not out. So don't worry about it. Jane thinks BK needs to replace her. I don't know if he can. But man, after she admitted it was his car publicly, and now she went after the judge and she went after the prosecution. Prosecution isn't really going to matter to her, and I don't think the judge is going to, be unprofessional. He doesn't strike me like that. But I think she made a mistake. I don't think she should have gone after him in the media. There's a gag order. She was circumventing the gag order already with her motions, saying that this is how we know that she is claiming there's no DNA in the office car. It's because she put it in her motion. That was releasing information into the mainstream. Now, we've had law enforcement make some leaks, but nothing recent. But the prosecution, I've never seen one news source cite a member of the prosecution leaked this or that. Nothing. So her saying that she didn't know what the questions are, I believe it's because she chose not to know what the questions were. And if I know this, if I believe this, I'm sure the judge is thinking the same thing. Girl Friday says exactly. Hey, Kimmy's been a channel member for 1 month. Yay! We have such a nice channel member group, and we have a nice group on Facebook too. If you want to come hang out with us, it's under Reporter Room on Facebook, and I have it linked in the description below. Come on and join. I have a page too, but I just use that to wave you guys into the Facebook group. It's a really nice group of people. If you're looking for just nice people to hang out with, or if you're looking for me, that's where I am. Viv says, to Jane, that's the feeling I got. It always seems as if Bill is letting the judge know his decisions are right, as if he's not sure of his own decisions. I think he is. I think he is sure. I just think that the prosecution is just reinforcing, because Ann Taylor was putting up a straw man argument. Her argument was, well, I told the prosecution what the questions were. Well, clearly she didn't say that today in the court to the judge. She said it to the press. She said it in the article I shared with you at the beginning, but she didn't say it today in front of the judge or in front of the prosecutor, not to his face. So I think that's really interesting too. Thanks for that, Viv. Jane says she will not get her change of venue now. I don't know. I mean, she's going to have to show something. Definitely want to hear the beginning. Yeah, please feel free to back it up. Mike wants to know, did her nose grow? I don't know. I don't even know what to think about that. But anybody who says, I mean, I'm not saying she's lying. I'm just saying she was misleading. Her saying that the prosecution knew ahead of time that she was doing this. I believe that she mentioned she was going to do a survey. I don't think she ever mentioned, and these are the questions I'm going to be asking, questions that are protected under this gag order. I'm going to include those. I don't think she ever told them that part. So is a half truth a lie? Yeah, I think it is. Jane thinks BK needs a new lawyer. Girl Friday said there's DNA. Yeah, there's DNA on the knife sheath found underneath into the side of Maddie. Kimmy says she words things very deliberately. Yeah, she's very good. Great Vince music. AT was womansplaining. Yeah, exactly. We was talking about mansplaining. Well, I felt bad for the judge in this case, because I felt like she was getting the opposite. He was getting womansplained too. Yeah. Ann Taylor is a sly fox. Jane is celebrating you, Kimmy. Angie says, I hope she doesn't get a change of venue. Girl Friday says, blood, sweat, skin, hair fibers. I feel it, maybe even from the dog, in my opinion. We don't know. And what we don't know is like what were those questions that Bill read a few of them that he knows everybody kind of knows about. But there was like page 3, he didn't bring up any of them. I'm like, and there's a recording of the guy calling to ask these questions. Somebody recorded it, and police reports. I thought one juror called, but reports was plural, not singular. So one person recorded it, but police reports was plural. So how many people contacted law enforcement, and what in the heck was being asked that would cause somebody to call the police after they got off the phone? I don't know. I think people need to leave the jurors alone. In the Alex Murdaugh case, we had Dick Hartpullian and Jim Griffin knocking on jurors' doors after the trial was over, trying to get a mistrial. Uh, and to me, I would just say, if you're a juror, don't open your door. If you don't want to have to go hire a lawyer, just don't open your door. Because a bunch of them had to go get lawyers after that. Yeah, Dinjaz thinks she's very sneaky. Karen. Ann is not to be trusted. Christine says he wants it moved. That's why she's done that survey. She would have a heads up on that. He wants it moved. That's why. You're talking about Bryan Kohberger? Yeah, it could be. Could be Christine. Oh, she wants it moved. Oh, thanks, Christine. I was like, trying to figure out who the he was, because we have the prosecution. Wicked agrees with you, Angie. No, she shouldn't, Angie. We have, yes, she should. No, she should. Okay. Jay says, Ann Taylor almost sounds like she doesn't understand the law very well. Well, we know she does. We know she does. She's capital punishment certified, so she understands it very well. She just decided, I would rather ask for forgiveness than permission. But I think it kind of backfired, because I think she thought she was going to come in with this data and she was still going to get her change of venue. She didn't. And if I were the judge, I would not want to move without trying to at least seat a jury in Latah County. The crimes happened in Latah County. If you don't want to have that jury decide your verdict, then don't commit the crime in that county. That's what I feel like. If you don't want to have a smaller juror pool, then maybe go to a bigger city to commit your crimes. But I know that's not legal language, so we'll just leave it there. That's just my personal opinion. Girl Friday said, is it because she can't deny his car was there? She admitted his car was there. She did worse than deny it. It slipped out. She was so busy arguing her pointing, trying to get her way in the last hearing, that she accidentally slipped it out that it was Bryan's car. She admitted it was his Hyundai Elantra. If I have the hearing posted, if you did not see it, it's toward the end of the hearing, so she's tired, and you see BK bolt out of that hearing afterward, and we were all like wondering, like, why was he mad about something? Like, what was he so upset about? Usually he says, thank you, or sits there nicely. He was out of there. Well, now I know why. When I went back to watch it, he was probably furious. She admitted it was his car in a live stream with everybody watching. And pressers. Yeah. Ann Taylor should not have gone to the press to complain. She just, she thought she was going to force the judge to do what she wanted. And he did. He was nice. He was polite about it, but he wasn't doing it. Kimmy said, we had to write an essay on the preponderance of the law in the OJ trials in government class last week. The similarities in the profile aspect are something to learn from. Thanks for that. Feel free to share your knowledge with us. Thank you, and Jazz. It was a good live. You guys made it so good. It was really hard to sit quietly, but I just promised myself I wasn't going to interrupt the hearing. And when it got going and I started hearing it, thank you too, Brother Mike. I just was like, this was definitely, woo! This was the best hearing so far. Last week was good in retrospect when I realized she had messed up and said it was his car. But in this one was like probably the most mad I've ever seen the judge. I'm sure he gets mad with defense or prosecution behind the scenes, but because she maligned him publicly and the prosecution publicly, I just think he wasn't having it. And she went behind his back. She knew there was a gag order. She knows she's responsible for her third party people. You can't have your investigators release stuff. It's not okay. Pam said this is a high profile case and she may be trying to make a name for herself. She could be trying to go out on her own to become a high powered defense attorney. That's exactly what a lot of people feel like, Pam. They feel like after this, she'll be able to write a best selling novel, millions of dollars in book deals, publicity tour, and she'll be able to bill a lot more an hour than she's billing now. She'll be able to name her price. And if she wins, even more money. Thank you so much, Cravid's Music. Barty says, I just saw they're at 30 some potential jurors for the Chad Daybell, so they might have their 50 by tomorrow. Okay, so I have Chad Daybell tentatively scheduled to trial to start tomorrow. I don't think it is. I think it's going to start Monday. So I'll look at that when I get done and just try to make a educated guess, because watching the jury thing is like it's not interesting. I tried to watch it today just thinking, well, maybe there's something to watch. I just thought it would be something to have on maybe if you're like in the cleaning, but I didn't think it was worth watching, in my opinion. Just it was like watching, but I think opening statements will be great. So we'll start the trial when they're going to start the trial. So I may be moving that. I thought we were starting last Monday. I did not realize in the Chad Daybell case, because all the press was reporting the trial was starting. I didn't realize they didn't have a jury seated yet. So, but I guess that is part of the trial. This is the first time I've streamed a whole trial, so I'm glad we can do the Chad Daybell case first. And then by Bryan Kohberger, I'll be an old hat at this. And Joe says this case will bring her fame and fortune. I think so too. Elaine says, how about BK's? Yeah, we never got to the alibi. I thought maybe we were going to get, this is what I thought. I thought we were going to find out about a court date, about a venue, and about an alibi. We didn't get any of that. She got a more delay, which she, probably wanted, but she also got chewed out. Woo. He was not happy. Angie says, don't think judge would let Kohberger remove her as his attorney at this point. I don't know. I don't know who he would get at this point to have somebody who's capital punishment certified. There's only 17 attorneys in Idaho that are capital punishment certified, and she is one of them. Ann Taylor knows the behavior experts will examine his every expression. Yeah, probably. Kibby says she's making bank. In this case, she's pulling out all the stops. I think so too. Holly wants to know, isn't the alibi hearing later? Well, I thought she could have given the alibi. I mean, not with everything that was going on, but I think there is a hearing scheduled for that. But I thought we were going to have it today. There'd be no reason, really. I mean, she's had months and months and months and months and months. She wants the video of Bryan, not Bryan in the car, but she wants to know if the prosecution has him on video. And then she wants to craft her alibi for him. But that's not the purpose of an alibi. The purpose of an alibi is just so that the prosecution and defense and the court don't all see the jury and then find out that he's on CCTV at the 7-Eleven, or he took a trip to Italy. He was overseas at the time. Yeah, she chooses conveniently. Yeah, thanks, you guys. You guys were great. Okay. Penny's here. Hey, Penny Royalty. She has to single-handedly go through 51 terabytes, but doesn't have time to dictate survey questions. Of course, she chose not to see. I mean, anybody who thinks she told them she didn't know, I don't need to see them. That I'm sure it went down something like that. So if the judge said, did you show them, that he could honestly say no, and she could honestly say, I didn't see them, but it was by choice. It was by design, but he's her responsibility. If you're hiring someone on behalf of the defense team, you're responsible for that person. Same thing with the prosecution. So if they're sharing inappropriate information or inappropriate photos, like what happened in the Delphi case, where somebody that worked in the attorney's office for Richard Allen leaked inappropriate photos that were not supposed to be shown to the public, and the judge was really mad about it. Bibitu26, I hope I'm saying your name right, said AT is just making money and negative fame out of the case. She will continue until stopped. Ken Tucker's like, go, go, judge, judge. Well, guys, I think I'm just want to say a very, let me grab this really quick. If you haven't subscribed, please do. I do want to say thank you so much to Jane J, our VIP red carpet. This is the first time I've had a VIP red carpet. Our producers, George Brown, Jazz, and Sasha Angel. Our awesome channel members. And I want to thank Jane J for gifting channel membership. Jazz last time gifted 5 channel memberships, which was, and the super thanks from Jazz. I got 2 super thanks. Thank you so much, Jazz. And then we have a new channel member, Hippie and Wicked. Welcome. I hope I haven't missed anybody. I hope I got everybody. Yeah, we couldn't, the channel members, we just so appreciate you. And thank you for this is like the last month or so for the super thanks, PayPal, and gifted memberships. Thank you so much. So Jane, I'll be adding your name to that next week. So yeah, you guys are awesome. Thank you so much for joining me for this hearing. Wow, I knew it was going to be a good hearing because just reading the press, that's why I wanted to do a pre-show with you to go through what she was saying in the media. I thought it was going to be a good hearing. And it was like, wow. So we're not going to probably be starting the Chad Daybell case tomorrow. So I'm going to have a Bryan Kohberger video probably come out instead. And because I have one I'm about to upload and one I uploaded last week. And then we'll probably be looking at the start date for opening statements for the Chad Daybell on Monday. I would suspect that's what it's looking like. So hit your notification bell so you don't miss it. That's an Idaho capital punishment case, and it'll give us a great preview as to what's going to happen in the Bryan Kohberger Idaho case. I think it'll be really good, and we can watch it together as a true crime community. Thank you so much for joining me, and I will see you next time. Thank you.